relying on a Supreme Court judgment that she had the accrued rights, not vested, but on the basis of accrued rights. Give her some relief, otherwise she just suffered. Of course, you can go for appeal. Yes. Yes. Huh.
Mention item number 7, Your Lordship.
Wait 1 second. Item number 7,
That-
yes.
I'm praying for some accommodation, Your Lordship.
Okay.
Can it be taken up after vacation, Your Lordship?
Mr. P. Khatunier.
Lordship.
Mr. P. Khatunier, learned counsel for the petitioner, prays for an accommodation and prays for an accommodation and prays that and further prays that the matter may be taken up after the ensuing vacation. Prayer is allowed. List this matter on 22nd of July.
Can it be on 24th?
Okay, 24th of July.
Ah,
Hmm?
Yes, my lord.
You are also there, right?
My lord, I'm
For the
the
respondent.
my lord.
Mr.
H. Burwa, my lord.
H. Borua appears for respond number.
SSA, my lord, on behalf of Mr. B. Gogol.
Representing SSA, Department of SSA, is present.
Lordship, there's an interim that may be continued.
Interim order passed earlier shall continue until the next return.
Will you
of
bless?
Withdrawal.
Lordship, actually, item 17, we prefer to withdraw, Lordship.
What about 18?
No, that's a different matter, Lordship.
Oh, because it is tagged, it has come up
Yeah,
together.
Actually, the subject matter of 17 has already been subsequently addressed in that second writ petition. So the petitioner no more wants to prefer item 17.
So your cause of action is included there,
Yes,
18.
So petitioner no more wants to pursue 17. Lordship.
Okay. Mr.
NZ Chaudhary on behalf of Senior Counsel A.R. Bhuya, Lordship.
Okay. Mr. N.J. Chaudhary appearing on behalf of Mr. A.R. Bhuya, learned senior counsel, submits that he has instructions to withdraw the matter. Prayer is allowed. Matter is closed as withdrawn.
If Lordship allows, then we have written instruction also. If required, we can place
What?
written instruction from petitioner.
For withdrawal?
Yes,
It's okay. I've already said
Okay,
we have
okay.
instructions.
Problem.
What about 18?
I think it will come, Lordship.
18 days no counsel here?
It's not required, actually. We have brought it by mention for withdrawal, item
Okay.
17, because it is flagged.
18 you likha representations are made from both the sides. List this matter on 16th of July.
All right.
Yes, Mr. Khan.
But your lordship may kindly peruse the order dated 5/5/2026.
5/5. Yes.
Order of
Yes.
dishonorable.
Yes, my lord.
Counter affidavit filed.
Look, affidavit is filed, my lord.
Hmm.
Basically, this honorable court, as per the letter that is at page 91 in the affidavit, my lord,
Hmm.
has sought for an instruction. What is the updated status, my lord?
Hmm.
Now, since my lord, I have talked to the secretary, my lord, till date the amendment has not been done.
Amendment of what?
Amendment, my lord, what happened, my lord? The earlier, my lord, there was no provision in the statute service rule, my lord, with regard to promotion of grade 4 to grade junior assistant. However, 2024 an amendment has been brought where 5% of the post from the grade 4, junior assistant will be filled up from the grade 4. Now, there is a proposal given by the director to the secretary, my lord, to the government, that though it is earmarked, the vacancies has been earmarked how it will be for promotion, but the procedure to be followed in that is not there in the service rule. And therefore, a proposal was made to the government that this, until that amendment is done, the promotion cannot be given effect.
But whether you require those procedures, it is
Yes,
already
because-
there in respect of other posts.
Yes, that is what, my lord, if your lordship kindly see the page 91, my lord.
So today, what is to be done?
I'll
You need
require
some time to.
ma'am. Let it be after vacation, my lord. In the meantime, I have
Okay,
talked to
Mr.
the
Khan.
secretary, my lord. We are trying to sort it out something.
They want the procedures to be brought on by way of an
Yes,
amendment.
But matter is that this proposal was made in the year 2024.
It's taking so long, Mr. Kaushik. It
24
takes long, you have seen.
24 because the amendment is of 24.
Her amendment this proposal because there is no prescribed rules. That's why this instruction was placed before the government.
So let us see another chance, okay? Because it takes time. I've also seen the departments takes time. There are so many other issues to be looked into. They heard Mr. M. Khan, learned counsel for the petitioner, and Mr. B. Kaushik, learned standing counsel for secondary
Secondary.
education. Mr. Kaushik submits that the proposal for amendment to the for further amendment to the
5-2.
Rule 5 of the Assam Secondary Education within bracket provincialized school service rules to 2024 is being processed, and he submits that he requires some time to submit the up-to-date status of the same. The prayer is allowed. List this matter on 16th of July, 2026.
Kamlesh.
Hmm.
May I please your lordship?
Hmm.
Lordship, the petitioner was appointed as a subject teacher, which is also known as a postgraduate teacher
Hmm.
in PM Sri Yadushree Saha HS.
Pleadings are complete, Mr. Kaushal. Affidavits are filed. It can be taken up for
Taken up for disposal, lordship.
Hmm.
There is urgency also, lordship.
Hmm.
He was appointed as subject teacher or postgraduate teacher on 6/11/1995.
Subject teacher
Subject teacher.
of what?
That is
Not relevant.
of PM Sri Yudhishthir Saha HS School, Behrabadar, Kachar.
Mm-hmm. Acha, acha.
Order is at page 15, lordship.
Okay. In PM Sri Yudhishthir Higher Secondary School.
Yudhishthir Saha High Secondary School,
Hmm.
Behrabadar, Kachar.
Behra Bazar Kasar. But
Kachar.
here you have not written Yudhishthir. What? Before
Yudhishthir-
HS you said something.
Yudhishthir Saha.
Saha is not there in your petition. Okay, then.
Perhaps I missed, lordship. The order is at page 16.
Hmm. Yes.
There, the name of the school is also clearly reflected. Yudhishthir Saha HS School.
Hmm. Okay. Also,
Uh,
okay, you are appointed as an assistant teacher.
No, subject
Subject
teacher.
teacher,
Subject
okay.
teacher is teacher whose appointment is on the basis of postgraduate degree.
Hmm.
So it is also known as postgraduate teacher, lordship.
Why there are two orders here in page 16?
Page 16, 15 is the type copy. 16 is the original one.
Okay. Hmm. Then?
Then, lordship, I continued as such since then, lordship,
Hmm.
and ultimately, in 2021,
Hmm.
upon retirement of the last principal, Srimati Monidipa Sikdar,
Hmm.
a vacancy has been created in the post of principal.
Hmm.
These are admitted, lordship, not
Hmm.
disputed.
When did she retire, you said?
In 2021, lordship.
Okay. Hmm.
Exact date I am not having, lordship.
It's okay.
In 2021.
Hmm.
Now, lordship, I am the senior most eligible teacher of the said school, lordship. Let
Okay.
your lordship.
So you are Kakoli Deb.
Kakoli Dev.
Okay, you are appointed as the in-charge principal.
I was before that, lordship, may kindly see the seniority list.
Okay.
I'll take your lordship to that document also.
Hmm.
Seniority list, page 21.
Hmm.
Original seniority list. Here, lordship will see my name is at serial number 4. My name is at serial
Kakoli
num-
Deb.
Yes.
Hmm.
There are 3 persons above me,
Hmm.
but those persons have become ineligible by virtue of having become 57 years of age, lordship.
Mm.
There is a provision in the rule, lordship, I will show. Once they become 57,
Mm.
they will become ineligible.
Mm.
I am presently 56 years of age.
Mm.
My date of birth is also shown there, 27/12/1969.
Hmm.
December, I will become 57 and I will also become ineligible
Mm.
this December. Now, lordship will see. So, I am the senior most.
But once a person a teacher is appointed as a principal, even if he or she becomes 57, doesn't matter, she can continue.
Thereafter, it doesn't matter.
Only
Once-
appointment.
Only appointment.
Then?
So accordingly,
Hmm.
this order was issued page 23.
Uh-huh.
Page 23,
Hmm.
in charge principal.
Hmm.
But this order was not served to me, lordship.
Huh.
Here one mistake is there, lordship. Here my designation has been shown as para number 2, assistant teacher. It should have
Okay,
been
this order was of 1907.
19/7/25. Here my designation has been wrongly shown as assistant teacher.
Okay.
It should have been subject teacher or postgraduate teacher as per my appointment letter, Lordship. That they have admitted in their reply also, I am a postgraduate teacher. Just to point out, Lordship. Then, Lordship, what happened? Page 24, the impugn order. This order, I'm reading this order, Lordship, three-line order. This office earlier order dated 19/7/25 allowing Srimati Kalokoli Dev as principal in charge of PMC registry so-and-so is hereby kept in abeyance until further order.
Why? What is the reason?
Reason, Lordship, this order is absolutely vague, non-speaking, unreasoned, Lordship. No opportunity has been given. So that's why I submitted representation, page 25. So I submitted representation.
After that order, you had joined, right? As an in-charge principal.
No, before I could join, they have kept the order in abeyance.
Before you could join.
Before I could join.
But that order was of 19/7.
Yes, 19/7.
After 1 month.
After one.
More than 1 month.
That time I was on leave, Lordship. That time I was on leave and this order was not served on me. I inquired in the office of, I have stated these factual aspects. I have approached the director of secondary education office. There I received this order. And by that time, Lordship, the day I received, next day, Lordship, they have kept this order. So I could not even join, Lordship, as in charge principal.
Okay, then.
So I submitted representation, page 25. And thereafter, they have kept silent. So I have approached this honorable court. Now my prayer is twofold, Lordship. Twofold. First, Lordship, my appointment, my consideration as to the regular post of principal in any of the vacancy in the district of Kachar. That is in terms of rule, I will show, Lordship.
I've seen it once.
It is the duty on them to carry out assessment of vacancy, invite application, entire process they should carry out in terms of rule 12 of the rules. Now, Lordship, and in terms of this order, being the senior most eligible teacher, I am also entitled to become the principal in charge in the meantime, till they carry out this entire process. I am entitled. Now they have kept this order in abeyance behind my back. So in the reply, their stand is only one ground, Lordship. Lordship will kindly have a look at their reply. They have enclosed one letter at page 33, a so-called complaint, Lordship. A so-called complaint. May I read this letter, Lordship?
By president of
SMDC.
the managing committee.
Managing committee. Managing committee. He is not the appointing authority. He is only to manage the school, Lordship. There is a blue-eyed boy of this person, Lordship, the president. This is actually a recommendation letter. Lordship will see. This is not actually a complaint. They have treated it as a complaint. I'm reading this letter. This is relevant, Lordship. This is issued to the director. Madam, I, Nikhil Chandra Dev, President so-and-so, have come to know from a reliable source the recent appointment of Kakoli Dev as principal in charge of the school. That, madam, it will not be out of point to mention here that although a married female teacher has got the right to enjoy CCL as per need. Such is the case with Kakoli Dev, who has enjoyed CCL several times, and ELs as well, earned leave. Being a highly enrolled PMC district is about so-and-so students, it is necessary to appoint an individual who can render his or her best possible service to such a PMC school. So keeping in mind the view of public interest, I am recommending Nirupam Nath, the existing academic in charge, whom I have recommended earlier also as well, and he is one of the senior most teacher, has also received Assam State Award of Department of Education. Moreover, he is energetic, enthusiast, strong local ties with which is essential for running an institution. Therefore, I would like to request you to kindly consider the case of Nirupam for appointment of principal. Regarding my thing, Lordship, he has stated as if it is a complaint. Now, Lordship, his allegation is that I have gone on leave, CCL and EL. It is not a case that I have gone on unauthorized leave. It is not a case that without informing anybody, I am remaining absent, I am not discharging my duties. This is not a case of misconduct. The CCL and EL, these are not a matter of right. I have brought this by the rules also I have brought by my reply, Lordship. Will see the CCS rules, childcare leave, Lordship, page 43 of my reply. Page 43. What is a child care leave, Lordship? A female has your Lordship got it?
Yes.
Page 43, para 3. A female government employee or a single male government employee who has minor children of 18 years of age and has custody of the child may be granted CCL by a competent authority on an application for a maximum period of so-and-so days, 730 days. Next, Lordship will come to next page, page 44. 44, subpara 12. The CCL shall not be demanded as a matter of right, and under no circumstance can any employee proceed on CCL without prior sanction of leave by the competent authority. Then 15 Lordship will see an application for CCL by a female employee and a single male government employee already on leave, leave other than so-and-so within or outside, who submits her or his application for grant of CCL may be considered, provided she or he submits the application 1 month before the expiry of leave. If CCL is not sanctioned by the competent order before the expiry of she or he shall have to join his or her duty. What I'm trying to show, Lordship, CCL is not a matter of right. The person, according to the rules, she will have to make application. Thereafter, they will consider and sanction it, Lordship. So I have applied according to my eligibility, and they have granted. So I was on duly authorized sanctions childcare leave, Lordship, as per the policy of government of India and government of Assam also. Then regarding earned leave, Lordship will see page 50. Earned leave, page 48.
48.
Page 48.
Okay.
Page 48. Page 48.
Hmm.
Subpara. Subpara.
Wait. Yes.
Para 2 subpara. Proviso.
This is amendment.
Yes.
Assam leave amendment.
Yes.
Rule.
Earlier, earned leave was 15 days. By this amendment, earned leave has been made 20 days, Lordship.
Achha.
And I'm trying to show, Lordship, these earned leave also, page 50.
What is this proviso to Rule 12? Provided you wanted to show me the proviso.
I wanted to show the proviso, sir.
Yes.
Provided that a government servant serving as teacher in a school under Department of Education shall be entitled to 15 days earned leave. 15 days.
Earlier it was 20,
Earlier
20
it
days.
was 20, now it is 15.
Uh-huh.
So she is duly entitled to 15 days. It is not that, Lordship, unauthorized absence or unauthorized leave she has been availing. That is not the case. Then page 51 also, Lordship can see. 51 also, serial number 1. This is regarding earned leave. Last line I'm showing, para 1, last line. The order sanctioning earned leave or half pay leave will indicate the balance at his credit. So there has to be a sanction. One has to apply as per application. It will be considered. It has to be sanctioned.
Yes.
So it is not a case of unauthorized absence. It is not a case of misconduct. It is only a recommendation. The Lordship will kindly see the complaint again. This President is recommending the name of one Nirupam Nath, a blue-eyed boy, Lordship. Nirupam Nath, wrongly stating him to be one of the senior most, Lordship. Now, Lordship will see, last paragraph is totally in his favor. It says he is some awardee, he is having local ties. Actually, he is an influential person. He has tried to manage the president and tried to get some orders in colorable exercise of power.
Okay, you have shown me the seniority list there. Nirupam Nath was not there.
No, he is there. He is below me.
Show me that.
Below me. Page, seniority list page is, it is at page 21. Lordship may again see, I am at serial number 4. Nirupam Nath at serial number 7.
Nirupam Nath.
Nirupam Nath at serial number 7. And Nirupam Nath, Lordship may kindly note, he is an assistant teacher. That is a subordinate post. That is a post on which minimum essential eligibility condition is graduate. For me, it is postgraduate. So that way also, I am holding a superior post. He is holding a subordinate post.
Okay, let me hear what he has to say.
Yes. And Lordship, kindly have a look at the rules, Lordship, for a moment, Lordship. Rules.
Important. Education manual.
Rule.
No, it's there. The book is there. It's not contained in the book.
Yes, it is. Book
Yes.
is there.
There na education manual kon. Na lage.
Assam Secondary Education Provincialized Schools Service Rules 2018.
Rules 19?
2018.
2018.
Assam Secondary Education Provincialized Schools Service Rule 2018.
Yes.
First, Lordship may kindly see a definition of a graduate teacher. Para 2I. 2I, Lordship.
Para 2-5.
2I.
Yes.
I.
Graduate teacher.
The third page. Graduate teacher means and includes the category of assistant teacher, classical so-and-so or high madrasa teacher including an amalgamated, for whose appointment minimum qualification is graduate in arts, science, commerce. That is Nirupam Nath. His qualification graduate holding lower post of graduate teacher. Next, Lordship will see in the next page 2P, 2P, postgraduate teacher. That is the petitioner. Means the category of postgraduate teachers in subject of art, science, commerce stream, vocational stream, including commercial, computer application of higher secondary, senior secondary, for whose appointment, the minimum qualification is postgraduate degree. So that way I am his senior. Now, Lordship will kindly come to Rule 12. The eligibility conditions and the procedure which is to be undertaken. Rule 12, Lordship. 12.1. 12.1. The post of principal in provincial as higher secondary school shall be filled up by direct recruitment from candidates among the cadre of postgraduate teacher or of secondary and senior secondary and higher secondary and graduate teachers of higher secondary school as per procedure under sub rule 5. Now, para 3, Lordship may kindly see. The minimum qualification for appointment to the post of principal in higher secondary school and senior secondary shall be as follows. Candidate must be MA, MSc, B.Ed degree from recognized having uniform good academic career. In respect of Hindi, this is not necessary. Then next, Lordship will see the candidate must have rendered at least 15 years service as postgraduate teacher in any of the provincial as higher secondary, senior secondary schools. Then it is Lordship will see 5, para 5 below. The age of the candidate must not be more than 57 years. As on the 1st January of the year of recruitment. Then Lordship will see the procedure.
Where is that?
Procedure para 5. Next page, Lordship. Next page. Rule 12, subclause 5. What is the procedure to be undertaken?
It's okay. The inspector will have to give the
Inspector, member secretary district shall make an assessment of the number of vacancies to be occurred in the cadre of principal to be filled up in the next year within the district.
So it is district wise.
It is district wise, and every year he will make an assessment. And after assessing the vacancies, he will invite application. People will apply, prepare seniority selection list, and thereafter appointment will be made. Now, vacancy in my particular school and various other schools in the Kasar district, Lordship, are remaining vacant since my school. It is since 21. After retirement of Moni Dipa. And other schools also many vacancies are there. So that is in respect of my consideration for regular appointment to the post of principal. And regarding in charge, Lordship, being the eligible and senior most person, Lordship, I am duly entitled and eligible to become the principal, which has been wrongly and in a arbitrary manner, it has been kept in abeyance, Lordship.
Achha, the requirement is all this, right? For
Requirement
being
is all
appointed as a principal for a postgraduate teacher.
Yes.
Right. But seniority is nowhere provided for.
That I am showing, Lordship. Lordship may kindly have a look at this judgment. Law is, Lordship, even for ad hoc appointment, the post of principal.
No, what is the criteria for promotion here or selection?
That your Lordship will see at para 12. 12.5.
This is the age.
No, 12
Oh, 5.
plus 5.
Okay.
12 sub plus 5. Criteria is seniority and eligibility, Lordship. Both should coincide, Lordship.
Okay.
Detailed procedure, Lordship. They'll invite application, prepare panel. Para 3, Lordship will see, on receipt of application from the eligible candidates, the district selection committee after scrutiny of the application shall hold an interview and prepare a panel of name of the 3 candidates against each vacancy for district on the basis of qualities such as so and so. So these are in respect of appointment on regular basis to the post of principal, against which I am just praying for a consideration, because regular principal, they should hold the process. I am not saying that I will only become the regular principal.
You through the process.
They should carry out the process. But regarding the in-charge principal, Lordship will kindly have a look at this judgment, Lordship. Regarding in-charge principal also, the person has to be the senior most and eligible at the same time. Para 8. Para 8.
Yes.
In this particular case, Lordship, one ineligible person who is junior, he has been given in charge and the senior most has been ignored. in this particular case. Para 8 I am reading, Lordship.
So
Coordinate
not seniority alone, but eligible criteria.
Eligibility I have shown, Lordship, I am eligible.
So
Senior-
eligible criteria is a leadership skill, administrative ability, integrity. These are the
These are for the regular.
regular.
But for in charge, Lordship, it is immediately it has to be given charge. So in
But
charge all this.
Paragraph 8 says that he has to fulfill the eligibility criteria for the regular post
Yes.
and not the seniority alone.
Yes. So eligibility and seniority, both things should coincide. Eligibility and seniority. So now, Lordship, I have shown I am the eligible person because I have completed 15 years. I am less than 57 years. I am the senior most person of the said school. So I have already shown para 12. I fulfill the eligibility, which are at para 12, 1, para 12, 12.3.1, 12.3.2, and 12.3.5.
So their contention is that you had taken those leaves.
Yes.
Right. And that was, I don't know, let me hear them, unauthorized and all. So she is not a proper candidate. So appoint him. And that is taken as a ground for keeping it abeyance.
Keeping in abeyance, they are not alleging that I have committed any misconduct. They are just trying to point out that I have availed leave.
Okay.
Availing leave cannot be a misconduct.
Yes,
It
that
also
she can.
does not show my credibility, Lordship.
Okay, let
It
me
was-
hear Mr. Kaushik.
I am entitled to the leave under rules, so I have availed, Lordship.
Yes, yes, Mr. Kaushik.
And in this particular judgment also, Lordship, there was a contest between the private respondent who are junior and the senior most person. They have given the in charge principle to the the junior most person. So court directed that you consider the eligibility and seniority and give the senior most person.
That is
That is their
reasonable.
This judgment,
But
if necessary, I'll take your Lordship after he completes para 10, the operative portion is.
no, give me that then.
I have given the judgment, Lordship.
I've seen that.
That is
Justice
para
Manas
8,
Pathak.
that is para 8, Lordship.
Huh.
They have relied on earlier judgment. But para 10 also, Lordship, may kindly see. Para 10. Para 10 also, I am reading, Lordship. For the ends of justice, Director of Secondary Education Assam is directed to pass a fresh order with regard to the principal in charge of the Behali High Secondary School that fell vacant on retirement of regular principal of higher education on so and so, determining the eligibility and seniority after giving an opportunity of hearing to the petitioner as well as the other eligible teachers of the said higher
Yes,
secondary,
okay.
including
I've
the
gone through.
now, Lordship, if at all, for a moment, if we assume that that person may be more efficient than me in any manner, Lordship. So for that also, Lordship, a proper assessment has to be done. I should also be allowed to participate if they are ready to.
No, there will be violation of fundamental rights if your
Definitely.
order is kept in abeyance without any proper reason.
Yes. If for in charge also they are willing to or they are eager to carry out some exercise, I should also be allowed to participate in that
participate.
exercise, Lordship. However, my contention is that for in charge, Lordship, only seniority and eligibility. will suffice.
Eligibility and seniority.
For regular, they can carry out all these things.
No, but then the same analogy will apply. Even in appointments of in charge.
For in charge, Lordship, if this huge exercise is carried out, Lordship,
Not that huge exercise, same criteria will be applicable.
same data, then both should participate, Lordship. Then other people are also there in the seniority list. Between him and me, there are 4 people, Lordship. So generally, as per the practice, extent practice and procedure, Lordship, always it is the senior most person of the school who discharges as the in charge principal. After
And a simple letter by the managing committee will not decide the entire issue.
it is actually a recommendation letter. He has gone to the president and president has issued a letter. I
Yes.
don't know what is the consideration. Lordship.
Yes, Mr. Kush.
Well, there's no dispute with regard to that the petitioner has the eligibility with regard to principal. Now, the seniority would not be a relevant factor for the purpose of regular appointment of a principal because it's a direct recruitment post. It's not a promotional post under the rule. Now, in terms of giving the in charge, this is a practice being followed, that the senior most eligible teacher is given the charge. Now, above the petitioner, there are 3 more senior teachers. Though,
They have crossed the age.
they have crossed the age, which is one of the criteria for appointment of a regular principal, which perhaps, though the department has taken into consideration, in my respectful submission, perhaps would not come in a way while giving an in charge. Now, and therefore, the petitioner was given the charge, but before the petitioner could take the could join,
Hmm.
there was a letter, it's not a complaint, though
Hmm.
it is being
Yes,
projected
I've
as a
seen that
complaint.
letter by the
It's a
SMDC.
it's a letter wherein, a concern has been shown by the managing committee's president, Now, this managing committee's president's concern
Hmm.
cannot be ruled out, apparently, because this is a school having a huge number of enrollment.
Hmm.
And his request of reviewing that order was in the public interest.
Hmm.
Since the principal is the one who would be managing the school, he has lots of responsibility attached to that post, It's not that the only the academic charge, he also have financial powers to be exercised while being an in charge, So therefore, there was a concern being made, and keeping note of that concern, the consideration was given by the authorities, and accordingly, it is not that the managing committee has recommended Mr. X to be given a charge, it's the inspector of school who has been given a charge by the department.
A managing committee has no role actually in all
Managing
this.
committee has role,
Acha.
Managing committee is the committee which is constituted, under the statute, and it is the committee who has to manage the affairs of the school.
Hmm.
So they have a role, The president,
Where is that provided for under the rules?
there is an office memorandum under which the managing committees are constituted,
Hmm.
And the school management and development committee, it is the school management and development committee, and they have been assigned with certain responsibilities, So it's not like that the managing committee doesn't have any role.
Hmm.
Managing committee has a role.
Wait, I'll come back to you.
Is there in the rule also?
Yes,
There
it is there in the rule also. So the concern of the managing committee was in public interest.
Hmm.
Though he has suggested some other name, which the petitioner has been alleging that that person is a blue-eyed boy.
Hmm.
However, since in the postgraduate cadre, there is no subordinate or superior teacher.
Hmm.
In the cadre wise, these are they receive different pay skills. There is no cadre wise that the graduate teacher is a subordinate cadre to a postgraduate teacher. So only the scale pay scales are different. And for the purpose of
But provisions are also different with respect to
only
postgraduate.
the experience,
Hmm.
teaching experience. Postgraduate teacher requires 15 years to become eligible for the post of principal. Graduate teacher requires 17 years.
Hmm.
So in cadre wise, it's not a subordinate or something, because since there is no promotion from a graduate teacher to postgraduate teacher, because these both are direct recruitment post. Now, if your lordship will kindly
Your only contention is that some amount of
consideration has to be
seriousness and
given to the
gravity is given.
because we are not more, the department, has to look into not just the interest of the teacher who is claiming to be an in charge, It's not a regular appointment also. Suppose
You have kept it in abeyance.
it's in
Now,
abeyance.
what is the stage? What have
It
you
is
done
the
now?
inspector
Stayed or what?
Now, inspector of school is holding as
Is
the
holding.
in charge.
He is running this
Temporary
school.
arrangement.
So it's a temporary arrangement, It's
There's
not
no
like
stay here in this
it's
matter.
not like that the department has facilitated the managing committee to favor somebody.
Hmm.
We are concerned about the school, we are concerned about the students. Ultimately, the school has to run.
Yes, that is the main criteria. But what about leave and all? Casual
Well,
leave and all those?
That's, it's not about the petitioner being faulted.
Hmm.
Since the petitioner is in leave or was in leave, therefore, the concern which was shown by the managing committee is, if your lordship will kindly see the letter, it's not nothing against the petitioner,
No, but then still he
he
about
says
leave.
that though it is a right of that
Huh.
the petitioner being a female employee,
Hmm.
but since the school has a huge enrollment,
Hmm.
so under such circumstances, the school would suffer.
In that case, he should have thought of before giving her the responsibility of in charge.
So that's the in charge is not given by the managing committee.
Hmm.
In charge order was passed by the inspector of school,
Hmm.
and inspector of school took into consideration the seniority list. There was nothing before the inspector of school to take any other.
No, as per the norms, you said in
Yes.
charge will be based on seniority.
Based on the seniority.
So he did
Since
well, good enough.
I believe the inspector since it is a requirement of giving an in charge,
Hmm.
whereas that 57 years may not would have been so relevant for
But then
but-
there is a judgment of this
No,
court saying that same thing should be applicable.
Jagannath Page's proposition is there, madam.
Hmm.
Jagannath, it says that the eligibility criteria that
Hmm.
is required for a regular principal
Should
is
be.
to be followed.
Hmm.
And that's malad the in spirit that was followed by the inspector and the petitioner was given the charge.
So what I'm thinking is, this letter has got nothing to do. It is
Yes.
only a recommendation. But this kept in abeyance will go. You follow a proper procedure if you see some misconduct on the part of the
But
petitioner.
the moment it is amounting to malad the captain events, if it is gone,
Hmm.
it's like giving the petitioner the charge.
Reviving.
Reviving the
Yes.
petitioner given the charge.
So after that,
So
if
in
you have some.
such a scenario, malad, what I would like to propose, malad, since the inspector is running the school, my lord will direct the authorities
Hmm.
to take proper recourse of direct recruitment for
That
filling
is-
up the
no,
post of.
that is, you see, it will take a bigger time, longer time, a bigger task. So it is district wise. So as far as in charge is concerned, this
Like
abeyance
in charge
order
side,
will go.
malad, there is no such indefeasible right, malad, to
No,
hold
yes,
the
there
charge.
is no.
It's a
but then
temporary arrangement
Huh.
done, malad, for the purpose of
till
till for the
regular.
functioning, malad.
Regular principal
Basically
is
a
appointed.
functioning.
But inspector of schools had seen this
Well, had it
seniority.
been a case, my lord, as somebody who is not eligible
Hmm.
has been given a charge, perhaps under 226, your lordship will have exercised the power of judicial review, my lord.
Hmm.
Since there is a violation of statutory rules, my lord.
Yes, there is no such violation, but then keeping it in abeyance without any proper reason is also.
No, the reason is, my lord, very well in our affidavit, my lord. It's your lordship will kindly come to paragraph 10, my lord.
10 page 31.
Yes, my lord. The deponent respectfully states that the issuance of the order by which the petitioner was appointed as principal in charge submitted an application before was appointed as principal in charge. The president of the SMDC, so and so,
Same thing.
submitted a, my lord, kindly see this second paragraph.
Hmm.
The reason, my lord. Accordingly, with a view to maintain the administrative decorum of so and so, the deponent issued the order dated whereby the earlier order was kept in abeyance and allowed the inspector of school to hold the charge of principal in charge. So it
Hmm.
is a temporary arrangement taken in the interest of the school, my lord.
But then, yes, inspector of
Malad,
school
that
is running,
public
but
interest, malad, cannot be ruled out, malad, in only for the purpose, malad, this since the petitioner
Hmm.
is eligible, malad. Malad,
But whatever-
petitioner has not been made
Hmm.
ineligible for somebody who is not eligible, malad.
But it is a letter from the SMDC. Maybe somebody had said something. You do
So let
according to
the
law.
director take a call, malad.
May I make
No, he
Well-
will again. I mean, I have seen what
So,
director
malad,
has taken.
your lordship will also have a given importance to the interest of the school, malad.
may I make a
Yes,
small
interest of
sub-
the school. You cannot say that she being the in charge will work against the school.
No, no, malad,
She has
I'm not
been
saying that.
working. Yes.
Malad, since if the petitioner keep on taking leave, malad,
It's okay. Then
Yeah.
you have all the right to take action against her. If she goes against the rules,
no, no, malad.
if she
It's
overstays,
not like, my dear, that she has gone on an unauthorized leave. Malad,
she had applied, she
Ye-
got the permission,
yes.
and then she left.
It is not
It is-
about faulting the petitioner, malad.
Hmm.
This is an order not
That's
faulting the petitioner.
fault on the part of the petitioner. Why should she be made to suffer? Right.
But that
It's okay. I'll
but
get
in,
the order.
vice
Yes.
versa, malad, the school also cannot be made to suffer, malad. If she keeps on
Provided
going on leave, malad.
if you see that school is suffering because of so many leaves that she takes, you have all the right to take action. Give her a show cause notice, proceed properly, but not by this letter from the SMDC.
Malad,
Right.
the SMD
It's
says,
okay.
yes.
One small
Yes,
submission,
right
one
away.
small submission, Lordship.
Yes.
Lordship, this submission, Lordship, that me acting as the in charge principal will affect public interest and the school also, Lordship, that is actually derogatory, Lordship, without any proper procedure, without
yes.
any charge sheet, without any so-called
Okay.
notice.
Heard,
And a
Mr.
right had accrued to me, Lordship, by that
Hmm.
order, Lordship, and that has been kept in a without opportunity.
Malad, that
This is
not be,
thermal, Lordship.
because the right
Hmm.
actually has not accrued because there was no joining. Before
Hmm.
she could join, that order was kept in abeyance. It's not like that
And
she has joined and that order was cancelled. Well,
No, anyways, you have
Lordship.
you have
Nothing but
appointed her.
penalized.
Accrued rights is there. Unless somebody joins
Nothing
and
but
give a
penalized.
joining
Start,
letter.
Malad, not an appointment.
That's okay. Heard Mr.
G.J. Sharma.
G.J. Sharma, learned counsel for the petitioner, and Mr. B. Kaushik, learned standing counsel for secondary education. By this application, the petitioner has endeavored to invoke the extraordinary jurisdiction of this court under Article 226 of the Constitution of India for a writ in the nature of certiorari for setting aside the order dated 27/8/2025, by which the order appointing the petitioner as in charge principal of PM Shri Yudhishthir Saha HS School, Behera Bazar, District Kachar, was kept in abeyance. Full stop. The petitioner has also prayed for a writ in the nature of mandamus, directing the respondents to give effect to the order dated 19/7/2025, by which the petitioner was allowed to act as a principal in charge of the said school. Full stop. A prayer is also made to appoint the petitioner as a regular principal in the said school against any available vacancy. The case of the petitioner is that she was appointed, right? It's a lady, right? She was appointed, yes, Pirimati. She was appointed as a subject teacher of logic and philosophy in PM, wo jo PM Sridhar referred to as the school girl na. Philosophy in the school, shortly referred to as the school, by order dated 6/11/1995. And in pursuant to the said order, the petitioner has joined the said school on 13/11/1995. And her services was also regularized by order dated 23/9/1999. And since then, the petitioner has been working as the subject teacher in the said school. While she was discharging her duty, it is also stated by the petitioner that although she was mentioned as a subject teacher or an assistant teacher, but she is a postgraduate teacher.
Assistant teacher. Subject teacher, postgraduate said. Although she has been mentioned as assistant teacher.
Where it is assistant teacher, subject teacher you have written, assistant teacher in the orders. Yes. It is stated that although the petitioner was mentioned as the assistant teacher of the said school, but she is the subject teacher, that is the postgraduate teacher of the school. While she was working, while she was working in the said school, during her service career in the said school, a seniority list was published wherein she is shown at serial number 4. Seniority list was of which date? During 2025.
18/6/25.
Seniority list dated 18/6/2025. She was placed at serial number 4. It is the further case of the petitioner that she being found eligible by the inspector of schools, she was appointed, she was allowed.
By the director.
By the director of secondary education, Assam. She was allowed. No, this order was by director, but something was seen, right, before her appointment.
Yes.
That was by inspector of schools?
No. He wrongly submitted.
Well, it's
Director.
It's director.
Okay.
No, earlier also, after the retirement of the earlier incumbent, the inspector was holding this.
Charge. She was holding the in charge. Thereafter, this order came.
Yes. Inspector was continuing as the charge.
Okay. Huh, কি করলাম? No, it is the further case of the petitioner that while she was serving as the subject teacher of the said school, the principal of the school retired during the year 2021, and since then the post of principal was lying vacant. Full stop. Subsequently, by order dated 19/7/2025, the petitioner was allowed to act as a principal in charge of the said school, along with the financial power to draw and disburse the salary, etc., of the staff of the school, in addition to her normal duties as teacher under FR 49 within brackets C by the inspector C of full stop. It is stated that pursuant to the retirement of the principal of the said school, as stated above, the inspector of school was holding the in charge principal of the said school, and thereafter the petitioner was allowed to act as such. The petitioner further states that she was on leave when that order was passed, allowing her to join as a in charge principal, and that before she could join as principal in charge, an order was passed by the Director of Secondary Education Assam on 27/8/2025, by which the earlier order dated 19/7/2025, allowing the petitioner to hold the post of in charge principal of the said school, was kept in abeyance till further order. Aggrieved by the same, the petitioner had filed a representation to the Director of Secondary Education Assam on 8/9/2025, but till date, she did not get any positive response. Any response, not positive, no, get any response. And as such, she filed the instant case before this court. During the pendency of the instant petition, respondent number 2 filed the affidavit in opposition, and in the same, a letter was annexed dated 22/7/2025, by which the president of School Managing and Development Committee had intimated the Director of Secondary Education Assam that, keeping in view the public interest, he recommended another existing academic in charge, namely Nirupam Nath, to be appointed as an in charge principal of the said school. Full stop. In the said letter, it was also intimated that petitioner, although had the right to go on leave, but the petitioner was stated to have enjoyed both CCL leaves, that is childcare leave, enjoyed childcare leave, both childcare leave as well as earned leave several times. And since the school has a high enrollment of students, the president of SMDC had expressed his opinion that it was necessary to appoint an individual who could render best possible service to the said school. Respondent number 2, apart from annexing the letter, had also stated in the affidavit that the petitioner had stated that to maintain administrative decorum of the school, the order dated 27/8/2025 was issued, full stop. The learned counsel.
Inspector was given the charge.
Full stop. It is stated in the affidavit.
Yes.
It is also stated in the affidavit that after keeping the order dated 19/7/2025 in abeyance, the inspector of school was given the charge of principal of the said school. Para. The learned counsel for the petitioner submits that the petitioner has been working in the school as a graduate teacher since the day of his appointment.
Postgraduate teacher.
Postgraduate teacher, Postgraduate teacher since the day of her appointment to the best of her capacity. And that she was appointed as the in-charge principal of the said school. He submits that calling back the order appointing her as in-charge principal and keeping it in abeyance was without any authority of law. He submits that the petitioner had taken leave, both CCL and EL, but then those were taken by the petitioner only after applying and after getting the permission from the appropriate authorities. As such, there cannot be any misconduct on the part of the petitioner, and the same cannot be a ground for keeping the order allowing her to act as in-charge principal in abeyance. In abeyance. To substantiate his argument, he has referred to the notification issued on 7th of April 2025, wherein the provisions relating child care leave as well as earned leave were mentioned. He has also placed Section 12 of Assam Secondary Education, within bracket, provincialized schools, rules 2018, wherein it is provided that both seniority and eligibility will be seen while giving appointment to the principal of the school. And by showing a judgment of this court rendered in Bikash Upadhyay versus State of Assam by this High Court in writ petition number 2122 of 2023, he submits that the requirement provided for in appointment of a principal, regular principal, should be also followed while during appointment of in-charge principal of any school. He as such submits that the petitioner, being senior to the other candidates, she was rightly allowed to hold the in-charge principal of the said school. He further submits that the teachers who were senior to the petitioner, as shown in the seniority list, had crossed the age limit of 57 years and as such, they having become ineligible. The petitioner was the only eligible teacher to be appointed to the said post. Para. On the other hand, Mr. B. Kaushik, learned standing counsel for the secondary education department, submits that the letter relied on by the respondent number 2 was not in derogatory of the petitioner's service to the school, but it was only due it was only made it was only written with the view to make the school run in its best manner, in the best possible manner. He further submits that while appointing in charge principal of the school, the norms that are usually followed is that the teacher should be senior to other candidates. However, he submits that there can be no difference between a graduate teacher or a postgraduate teacher in allowing a teacher to hold the post of in-charge principal. He also submits that it is an admitted position that petitioner had taken leave both CCL and EL a number of times, and it is only for the betterment of the school that the said order was kept in abeyance by respondent number 2. He also submits that petitioner had not gone and joined as the principal in charge of the school, and that no rights had accrued to her in view of the order dated 19/7/2025. I've heard the counsels and have gone through the records as well as the law relevant for the purpose, and this court finds the following. The petitioner was admittedly a postgraduate teacher, a postgraduate teacher appointed in the school by order dated 6/11/95, after which her services was regularized and she was working in the said school since then. She being the senior most teacher in the school, after 3 numbers of teachers who had crossed the eligibility criteria for being appointed, right, in charge or allowed. It's not appointment. For being allowed to act as an in charge principal, she was allowed for the same. It is not full stop. It is not her fault that she went on leave during the order when it was issued. That is on 19/7/2025. And when she came back after the period of her leave, she found that she found both the orders passed that is on 19/7/2025, when she was allowed to work as an in-charge principal, and 7/8/2025, when that order was kept in abeyance. It is further seen that the order allowing her to serve as the in-charge principal of the school was passed by the Director of Secondary Education, Assam. And the letter that was written alleging that she had taken leave a number of times and that another teacher would be more suited for the post was by the president of SMDC of the said school. It is also seen that the said letter was in the form of a request for review of the approval given for appointing the petitioner as principal in charge of the said school. And it can by no stretch of reasoning be the basis for keeping in abeyance the order by which the petitioner was allowed to hold the in-charge principal of the said school, hold the post of in-charge principal. If any misconduct is seen in case of the petitioner, an entire procedure is provided for under the rules. It is also seen that the petitioner had taken leave in the nature of child care leave or the earned leave after duly applying and obtaining the permission from the authorities. The respondent had also not stated in the affidavit about any misconduct of the petitioner. Further, it is already settled by this court that the criteria applicable for appointment to the post of regular principal of the school should be made applicable even in cases of appointment of in-charge principal of the school. And in the said rules, both eligibility and seniority should be taken care of. And a detailed procedure is provided for appointment to the post of principal, which is by way of a direct recruitment. But in case of appointment of in-charge principal, the normal procedure followed, as could be seen from the case laws, that seniority is seen. In view of the same, the petitioner being found senior in the school was allowed to hold the post of in-charge principal. On the other hand, Mr. Nirupam Nath, whose name was recommended by the SMDC, was at serial number 7 of the seniority list. That is, after 3 candidates from the petitioner. Furthermore, the teachers appearing above the petitioner had crossed the 57 years of age for appointment to the post of regular principal, which again should be considered while allowing teachers to hold the post of in-charge principal of the school. As such, the order dated 27/8/2025 is quashed by this court. And as a natural corollary, the petitioner should be allowed to join as an in-charge principal of the said school. Further, if any misconduct is seen on the part of the principal, the authorities are directed to take action as per law. Petition is disposed of.
Lordship, one small thing, Lordship. Can it be liberty instead of direction? Because if direction is issued, they will point out something, Lordship.
Oh, for
Subject to
that
what your Lordship
misconduct.
said. Misconduct. It is a direction.
Acha, liberty.
Liberty.
Okay, it is, what did I say? The Director of Education is given the liberty to proceed against the petitioner if any misconduct is found on her part,
And
as per rules.
as per rule,
as per law.
that without liberty also, otherwise they
No,
can.
yeah, that is why.
Lordship.
Okay.
And there was another prayer for regular appointment.
And that I thought of, that it's okay, you participate.
No, they have not conducted the procedure. As
So
per
That is
the
fine.
advertisement has to
That
be.
advertisement, there is a detailed procedure.
retail procedure, every year they will have to assess vacancy and they will have to carry out.
This is not in the nature of PIL. It's okay, you
no,
are
I am-
back here.
Now I am eligible.
Huh.
Now I am eligible. From December onwards, I will become ineligible. So I am eligible, so I should be given a consideration for that, Lordship, under the rules, because.
You
rules
make a separate representation for that.
Once the advertisement is issued, my lord, he will get a consideration if he participates.
Huh.
No, but
Now there is no bar, you
since-
can
It's
participate.
Since
quite
2021,
premature now.
at least since 2021, they have not issued advertisement. It has been more than 5 years. And rule says, Lordship, every year they will have to assess vacancy. Every year they will have to issue
No,
advertisement.
this is an adversarial litigation. I'll not go into all this. Okay.
Because I lose one scope for getting a higher scope
No, my
of
lord,
regular
it's not
appointment.
like that. my lord.
Okay,
It's-
it is further directed that the Director of Secondary Education will consider filling up the regular post of principal in the different schools in the district by initiating the process under the rules at the earliest, since the petitioner along with others will get ineligible with every passing months. Okay, petition is disposed of.
Some-
What else do you want?
Some time frame, Lordship, earliest, Lordship.
No, my lord, that's.
Some
At
time.
the earliest, at the
But in
earliest.
fact, my lord, this is something, my lord, which my friend is praying me.
Mm.
It's not that, my lord, the petitioner has a right of getting consideration within that district.
Mm.
Other districts, advertisements were issued.
Yes.
So he did not participate. He cannot
No,
have
no,
a
no.
choice of my way or highway, my lord.
Mm.
That only when the Silchar advertisement will be there, I'll participate.
Okay, okay.
If he is
Yes, that
eligible,
is
he can
enough.
participate everywhere.
They will consider holding it at the earliest as per law. Okay, next matter.
Obliged.
Item 3 है निखिल हो सर एक कॉन्टैक्ट दीजिए अपना Yes, item 3, yes, what?
Lordship, pleadings are not complete. Lordship, may kindly peruse the previous order dated 25/5/2026.
25/5.
Yes, Lordship.
It is seen that the respondents have taken time to file affidavit, but when an address
Last opportunity was
has
provided.
not
to them.
filed, as such, learned counsel has given a. Okay, you have not filed the affidavits. Respondents.
Really, we still await instructions. We have,
Achha, this is a matter of 25. You file it by the next day. Or else proceed without the so and so, without the affidavits. Someone has filed. No, nobody has filed.
there's page 55 in the petition. We have 55 and 60.
Huh.
Um,
Okay, you filed the
yeah,
affidavits soon.
page 55 and 63. We have sought instructions couple of times
Yeah.
because from our end, the stand is that we can condone. However, there is supposed to be a rule for
Mm.
which we need to seek permission from the finance department, for which we have sought the permission. We have not gotten instructions on it. Give us any short time, we'll file our.
If you don't get your instructions, we will proceed without those. Okay?
Our case is, Lordship, condonation is not at all required, Lordship. They have completely disregarded my past service.
The
Acha.
KVK
Otherwise not required.
KVK cadre is totally distinct from the AU mainstream cadre.
Acha.
The petitioner was absorbed in the 2020, and as per the AU rules, the petitioner needs to complete at least 1 year of full service without any
Acha.
break to get the.
Okay, you incorporate that. With
let them
it
file
will be after the vacation only now.
No issues.
Heard
Any shorter after
Mr.
this.
P. Khatonia, learned counsel for the petitioner, and Mr.
S. Sharma,
Ash Sharma for respond number
2345.
2, 3, 4, and 5. Although by the last order, the respondents were allowed time to file their affidavits, but when the matter is again called up today, it is seen that the respondents had not filed their affidavits. Mr. Sharma had submitted that Mr. Sharma submits that a short span of time be allowed to him to get the instructions for the last time. The prayer is allowed. List this matter immediately after. List this matter on 17th of July 2026, by which date the respondents would file their affidavit, and on failure to do the same, the case will be proceeded without the same. Yes, Mr. Sharma.
Petitioner being the first wife has been receiving provisional pension for last 14 years till finalization of the pension, regular pension. Only my limit.
14 years she got provisional pension.
Yes, from 2012 onwards till
Acha.
today. So only my prayer is that that my pension may be finalized within a time.
You are the second wife,
First wife.
or you are the first wife? Second wife was also given something.
There are some agreements she has received from 2003 to 2012, along with leave encashment and gratuity. From 2012 onwards, till finalization of regular pension, I will be entitled to receive all the regular pension.
The
The
remaining part of the pension.
Maybe my lord, that is not on record, what agreement is there. And secondly, my lord,
Director has also submitted proposal in the year 2017 to the Director of Pension for regular pension.
So
that proposal was there, my lord, but
Rest
second
20
wife is not party here, firstly. Secondly, my lord,
he's not for, he's for first wife. He will give something from there, I think.
well, why it has not been finalized, that is not, that instruction today I don't have, my lord. So my lord may take it after vacation so that I can obtain the instruction if there is not any dispute, my lord, that,
Or you
That's-
finalize it, I'll give you a time limit
That is
that
the-
can be done.
and
But
give him,
only
give
thing
her.
is that if there is dispute between the first wife and second wife,
That dispute is not the matter of concern here.
not.
That will be again by separate case.
My lord, I am appearing for the director of pension. My prayer before your lordship today, my lord, let some instruction come, my lord, then it will be better to, my lord, pass an order, appropriate order.
What instruction? You see,
Why that, my lord?
he is entitled for the pension.
I am-
He is entitled.
If
I am
there is
receiving-
dispute, my lord, for that dispute, my lord, it has not been finalized for long years. That instruction, perhaps, my lord, will be necessary.
Let them take. Okay, heard Mr. U. Sharma
And Sharma.
and Sharma, learned counsel for the petitioner, and Mr. N.J. Khatuniar, learned standing counsel for
secondary education.
secondary education, and Mr.
Sharma.
Sharma
My lord, director of pension.
for director of pension, representing respond number
4, my.
4. And Miss Accountant General, huh? A. Sharma on behalf of B. Chakraborty, and you Miss R.M. Bora of Finance Department. The learned counsel appearing for the pension department states that he be allowed some time to get the instruction as to why the regular pension is not being paid to the petitioner. And has prayed for some time. Prayer is allowed. List this matter on 15th of July.
Yes.
You bring the instruction. Why you keep her hanging? July 2026.
And Robert shall be made on the next date, my lord, if instruction.
Endeavor will be made on the next date for disposal of the present case.
Maybe the lordship. The notice was issued in the last occasion, my lord.
Huh.
Affidavit filed.
So today what is to be done? No affidavits by either of the respondents? Yes. Come, sir, don't run. Come slowly. I'm still-
Respondent number 9, Lordship. Our name has not been shown in the course list, Lordship. As well as
Respond number 9 is
nine,
who?
we have
Item number, no, I don't know.
item
six.
number 6, Lordship. We
Huh?
have impleted item number 6, Lordship.
Respond number 8, man, not 9.
8 or 9. Lordship. We
This
have-
is item number 5. 5 you are there?
No.
5 I am not, Lordship.
Six you are there.
Interconnected case.
Huh. So Mr. Khatuniar appearing for?
I'm the education department, madam. I'm for the education department. Otherwise,
You-
we don't have any role, madam, because this is regarding settlement of land.
Revenue department,
Settlement of ceiling surplus land.
yes.
Why will they be allotted to you?
I have applied, my lord.
Oh, that is a school, right? I
They have
remember.
already made proposal, my lord.
Huh.
Proposal also there.
So, who is the
District Commissioner.
relevant party here, huh?
District Commissioner.
So, district commissioner,
That, my lord, as per the order passed in I 1530/2026, house title is required to be amended. That amendment has not been done.
it is in item number 6. As far as 5 is concerned,
Connected, my lord, total connected.
you will implicate yourself in 5 also.
In six lordship, but land is lordship, both land is same area lordship, same land lordship, both institution.
So, you are, okay, you file an implementing application then.
We have already filed implement petition accordingly. This honorable court in order dated 15/5/2026 in IA number 1530, our implement petition has been allowed lordship. Accordingly, he has directed.
Oh, you have not filed cause title.
I already filed.
He already filed, but lordship,
Huh?
our
Huh?
name has not been
Item number
shown.
6, my lord. That is item number 6.
Acha, not in 5.
And that's why lordship, a corrected writ petition may be served to us lordship.
Only cost title, my lord. Entire petition is.
Only cause title.
Yes.
A change will be done in the CIS system.
Yes, yes. That is
Every-
definitely done.
everywhere
That is
same.
by the registry. He will have to file only the amended cause title petition.
Yes, submit, my lord, before the registry, my lord.
Accordingly-
No, he had submitted, he said.
Submitted, corrected writ petition is required, lordship. Something changed, lordship, maybe change in the writ petition, lordship, in the cost title also.
No, corrected writ petition is not required. Same writ petition will do. An amended cost title has been received in terms of the order. Therefore, implement of respond number 8 and so in the same tagged. According necessary changes has been carried out. Necessary changes were also carried out in CIS.
Then, lordship, our name has been shown, then matter may be fixed after vacation, we will file our objection in this case. Our name today has not been shown.
In item number 6, you write, Mr.
ABT of lordship.
ABT Hawk, Learned Counsel for newly implemented respondent number 8, submits that a copy of the writ petition has not been served upon him, and further praised that the matter may be taken up after the ensuing vacation. It is as such directed that the learned counsel for the petitioner may serve him a copy of the writ petition at the earliest. List this matter accordingly on 17th of July.
Our
20
name may be shown in the cost
so-
title.
so- so and so.
Published.
It is further prayed by the learned counsel appearing for the newly implemented respond number 8 that his name may be shown in the cause list. Registry is directed to reflect the name of Mr. ABT Huck, a learned counsel representing respondent number 8 in the cause list. In number 5, you write, parties are represented. List this matter on 17th of July, as prayed for. Yes.
May I please?
Yes, Purvasta.
My lord, the petitioner is not getting the pension, the monthly pension since October 2017. And
October 2017.
Yes, lordship. Earlier, he was getting the regular pension, PPO was sanctioned, everything done, my lord. But presently, he is not getting. And the last association bank was directed, my lord, to give the report, my lord. And we have also given the life certificate, everything is done. But as on date, money has not been credited.
So education department was supposed to file an affidavit. What happened is
But, after issuance of the PPO, departmental authorities have, I think it might not have any duty.
Role, my lord.
It is
This
the
is
duty of the bank and the
Pension.
only the bank. Bank has to give the
Pension department has given the money to the bank.
they have issued the
Sanction.
PPO.
Oh, they
After
have issued-
issuance of the PPO, it is given to the treasury and treasury sends it to the bank.
Mm.
It is now in the bank and banks paid the pension till October 2017.
Mm.
After that, they have stopped. They have stated earlier occasions that life certificate was not there.
Mm.
Petitioner appeared in the bank and submitted life certificate.
Then what is the bar now?
Lordship, actually the life certificate.
What is this? This is an instruction by Ms. Chutia. This is an instruction by you.
Yes, ma'am.
Director of pension has sanctioned the pension payment order. Petitioner, retired headmaster of so and accordingly monthly the petitioner since 2009. हाँ ये जल्दी जल्दी टाइप कर दो, ये जल्दी जल्दी टाइप कर दो. 2009 through Punjab है accordingly monthly pension has been received by so Punjab National Bank. Does it mention here the concerned bank and the director have a concern for monitoring and set? Okay, so they have put their hands off, they have no role. So they have also said,
Director of pension,
hmm,
give the instruction that if you has been issued from bank, the reason for stoppage of pension is known to the bank and treasury.
bank and the
Treasury.
treasury. So they wanted the life certificate that was given.
Yes, Your Lordship. We
Now-
have received it on 5th of May, Lordship. But now we are waiting for the direction of the clearance of the Treasury Department, Lordship. Because last transaction.
Who appears for the treasury? Government advocate.
2018.
So, okay, I'll tell you to give the necessary order to the bank.
We will complain.
And so the bank will give the amount, okay? Heard Mr. B. Purkastra, learned counsel for the petitioner and learned counsel for the petitioner and Mr. M. Yeah, Mr. Yes, your name please first.
I am Boraya Lordship.
R.M. Borua for learned government advocate.
No, I'm for the finance department and treasury department.
Acha, learned advocate for learned counsel for the finance department. Miss S. Chutia. Representing respond number 1, 3 and 5 and Mr. M. D.K. Dharmendra Kumar Sharma for respondent number 4 and your bank
D. Gogoi, Lordship.
D. Gogoi for respondent number
On behalf of SCPNB, respondent number 8.
respondent number 8. That is the bank official. By this application, the petitioner has prayed for, by this application, filed under Article 226 of the Constitution of India, the petitioner has prayed for payment of pension, prayed for a writ in the nature of mandamus, directing the authorities to pay the pension, pay the pension which was stopped from October 2017 to the petitioner.
Up to
Full stop.
October is-
A further prayer is made that the interest at the rate of 18% per annum should be paid to the petitioner from October 2017 till date. The case of the petitioner is that he was working as a teacher in Konapara Grant ME School. Konapara, K. Konapara Grant ME School.
As headmaster.
No, কি বলে করলো petitioner? So in Konapara, and later on he was also appointed as the principal headmaster
Headmaster, yes.
of the said school. And that he retired from his service on
36, 2009.
where is that 36 2009. It is the further case of the petitioner that he was getting the current regular pension
Yes.
from the date of his retirement till October 2017. And that thereafter, his pension was stopped for reasons known to the authorities. Later, what happened? Later, he was informed.
I have come to know, my lord, as the pension is stopped, thereafter I have come to the duty.
Later, he was informed by the authorities that his pension was stopped due to non-furnishing of life petitioner by the petitioner. Full stop. The petitioner, in compliance of the petitioner, as such, appeared before the authorities of the bank and submitted his life certificate. Full stop. That was done when?
In the month of May, my lord.
Month of May, Lordship.
This May,
Yes.
in the month of May 2026. But what happened in the earlier years? You have not. From 17,
I was not informed earlier, my lord. After filing of this case, only we have come to know.
It is also the case of the petitioner that he was never informed of the reasons as to why his pension was stopped. And when he filed the instant writ petition, he was apprised of the same and had submitted his life certificate as stated above. Yes, sir. The Learned Counsel for the Education Department had placed one instruction has placed one instruction by which it was informed, has placed an instruction dated 26/3/2026 by which it is intimated that no, before that you write it how bro before that you write the Learned Counsel for the petitioner submits that he has information that the pension payment order was given to the Treasury Department as well as to the Pension Department, but till date the authorities in the Treasury and Pension Department had not acted upon. Full stop. The Learned Counsel for the Education Department has placed an instruction, has placed an instruction dated 26/3/2026 by which it is intimated that the Director of Pension Assam had sanctioned the pension payment order wide number ADP / PPO / GPO / 2010 / 003504 in respect of the petitioner who had retired as a headmaster of the said school, and that in the strength of the said PPO, the pension was given to the petitioner since the date of his retirement till October 2017. Full stop. Which is further intimated that the concerned bank and the Director of Pension are the competent authority for monitoring and settling the matter. Full stop. The Learned Counsel for Pension, Mr. D.K. Sharma, submits. Where? You had given a letter.
Yes.
Submits that the pension payment order dated 3/12/2010 was issued from the Directorate of Pension, and the reason for stoppage of pension is not known to the said department. Full stop. The Learned Counsel for Treasury, Ms. Borua, submits that PPO will be what happened? You had not given the PPO to.
No, Your Lordship, the PPO is issued by the Director of Pension. We are only the disbursing authority, Your Lordship. So, Your Lordship, our role ends when we disburse the amount. The bank is on.
You had disbursed?
Yes, Your Lordship. The
What
life
is
certificate.
all, of the petitioner that has not received my lord pension, because each and every year, in the
Year.
month of
Yes, Lordship.
November, life certificate is required to be.
Yes, each and every year,
Yes,
even
Your
I had seen my father
Yes,
doing
Your
it.
Lordship. In the bank, Your
This
Lordship,
is
and then
fault
get
of the
disbursed.
of the bank and other authorities.
Mm.
This is the fault of the petition.
Yes, Ms. Borua had submitted that the disbursement has been done by the Finance Department in connection with the pension of the petitioner to the concerned bank. Full stop. Para. The Learned Counsel appearing for the bank had, however, submitted that as per requirement, the life certificate is not deposited each year was submitted, deposited, submitted for each year by the petitioner, and as such, pension could not be disbursed to the petitioner for the same. He further submits that it is known to every pensioner that every year the life certificate should be given. And due to absence of the same, they could not pay. para kori dia. In consideration of the submissions made by the councils for all the parties, this court therefore directs the petitioner.
The
This
petitioner has
court,
already submitted.
therefore, and for other years also you keep giving.
Yes, now
It is directed that the bank authorities having received the life certificate of the petitioner for the present year should disburse the pension amount as per the PPO mentioned above to the petitioner. And the petitioner is also directed to deposit the life certificate every year so that the present problem does not arise. Petition is as such disposed.
My lord, with effect from November 2017.
Oh, yes. No, তাৰপিছত লিখা. The bank, what is this bank?
Punjab National Bank.
The author of the respondent number 8 is further directed to release the pension accrued to the petitioner since October 2017 till date, and along with the interest, whatever is permissible under the rules. Petition is disposed of.
Obviously. Obliged.
Yes.
Also, this petition is filed for correction of my posting order also at the senior most in the school. And in the district wise selection list also, also my.
Transfer order.
Not transfer lawsuit, I have been promoted, but all the, in all other cases lawsuit, the senior most incumbent has been kept in their own school. My, in the Gaddison list, district wise Gaddison.
No, I did not get you. What?
Lawsuit, there is a recent promotion of the.
You have some prayer.
Lordship, I will file my affidavit, your lordship, it came.
Well, perhaps not needed, Miller, because the representation of the petitioner has been rejected, Miller. If he is aggrieved now, he will have to challenge this.
Oh.
No, representation has been disposed of blame. They have to file the affidavit, I will respond, lawsuit.
No, government has already taken a decision, Miller, that his request of giving the posting is rejected.
So
That is,
you had.
that is on my representation. That is why also I have challenged, I have come before this honorable.
But this is not on records now. Rejection of your.
They have to file their affidavit also so that I can respond. Because in the Gaddison list, my seniority position is 24. The respondent number 5, her seniority position is 41. In all other
Mr.
schools-
Kaushik, this is not actually a contempt proceeding and all. This
That's
is where
correct.
he has to.
Well, in fact, Miller, what the petitioner is praying for, Miller, he is praying for that with his promotion, he should be retained in his own school.
Oh.
There is nothing in the rule as such. And what he is claiming is that since I am in the seniority provision, in the district seniority list, I was senior to the respond number 4. Therefore, I should have been given my own school.
That
And
cannot be.
that is also
That
not
cannot
there
be,
in the
but
rule.
in all the schools, lots of the senior most incumbents have been retained in their
No,
respective.
that's
schools.
not a part of record. I
And
cannot answer.
Some wrong is done. That cannot be
Those
done in
who are
respect.
located in the low rank, they are placed elsewhere. In all schools, lots of the senior most incumbent has been kept in their own.
But we are not concerned with other cases. But in your case, rule has to be followed, and then
Yes.
there's
So-
nothing mentioned in the rule that
And
you
the
will be in the
senior-
home school,
I'm
your
a
own
senior
school.
most, lots of.
Senior
So I
post
said-
doesn't matter. You will be posted anywhere in the district. What post? Principal,
Headmaster.
headmaster.
It's a district-wise selection.
This like principal district-wise
So
selection.
lots of, we can see the district, the Gaddison list of the district-wise selection lots of.
But then you cannot be posted in your own school where you had served as a teacher.
No,
Well, there is actually, Miller,
No,
there is
that
no
is-
bar.
that is not a correct question.
But there is no enforceable right also to claim that I have to be posted in my own school. It's
So
a
where is the posting norms, lots of? Whether they have followed the posting norms?
Where is the posting norms given?
Lots
there
of-
is no such posting norms. Miller.
Then.
So in
as-
the- so as they will have to go by the Gaddison list, district-wise
No, no,
Gaddison list.
That's
And all the
something
income,
which is
all the.
beyond
But
the.
what I have
See, all
gone.
the senior incumbents in their respective schools have been retained. I'm the only exception, let's say, where I have been sent to a different school. That is my grievance as well.
But as far as I have gone through the rules once, then it is said it is a district-wise thing.
District-wise-
Headmaster is again a direct recruitment, I think.
Yes, Lordship.
Headmaster is a promotion.
Promotion.
Oh, promotion.
Promotion from the district-wide seniority.
And-
Earlier it was, before 2018, the rule says, it was a school-wide seniority.
Huh.
So therefore, the people used to get it in their own school.
Hmm.
Now it's a district-wide seniority.
Hmm.
Also, let them, whatever the director has passed an
Now,
order.
first,
them
let
bring
the
on-
petitioners satisfy your
Yes,
lordship,
Lordship, I can
that
satisfy.
he has a enforceable right under the rule, for
Eh,
choosing his own
It-
choice of
it
posting.
Taken up today instead of again giving them.
If the affidavit comes, so that I can respond, Lordship. What they have given.
Well,
I have
I'll
not seen,
submit from rule.
I have not seen.
Okay, will you file an affidavit? He wants to go through the rejection order.
So that I
Oh,
can respond,
rejection.
Lordship.
Or a
Rejection,
copy,
rejection order, a copy I can
a
give.
copy he can give.
I can give him a copy.
Okay.
I waive an affidavit, Lordship, it would be better, Lordship, so that I can respond. No, this is passed only in terms of my representation. I have already stated in my writ petition.
Okay. Heard Mr. S.K. Das, Learned Counsel for the petitioner, and Mr. B. Kaushik, Learned Standing Counsel for Secondary Education Department, and Mr. S.A. Hussain for respondent number 4. Mr. B. Kaushik, Learned Standing Counsel, has placed an order passed by the Director
Director of Secondary Education.
Director of Secondary Education Assam, by which the representation submitted by the petitioner was rejected for his choice of posting. For his posting
Lordship.
in a different school,
In my own school. Yes, Lordship.
in a different school after he was promoted to the post of headmaster.
And Lordship, I being the senior most, Lordship, I have only.
No, it's only a line.
I have only 18 months left, Lordship.
Okay.
Before retirement, Lordship, they are kept in their own places, Lordship, not listed.
Okay. A copy of the copy of the said rejection, the copy. No, no, it's okay. You can give it to him.
No,
A copy thereof is should be given to the learned counsel appearing for the petitioner, who submits that he will go through the same and place the case.
My prayer is for filing an affidavit so that I can respond, Lordship, by way of an affidavit, Lordship. Because this is on my representation, Lordship. What I have stated in my writ petition. Lordship.
Okay, you file a small letter. Yeah, it is who has placed the instruction how. Tarpisat dia Mr. Kaushik, learned standing counsel, prays for some time so that he files an affidavit bringing on record the said rejection order. Prayer is allowed. List this matter on 15th of July 2026.
No, let it be 4 weeks, my lord. I'll file my detailed affidavit.
List this matter on 22nd of July
My blind
2026.
friend, caring for respondent number also prayed for filing an affidavit.
The other respondents are also given the liberty to file their affidavits.
He will not give.
The copy of the copy of the rejection order is placed and made part of the records. Yeah, that's right. Yes.
May I please, Your Lordship?
What key matter?
Tutor, my lordship.
10. 10. Yes. What happened?
You be a tutor, my lordship.
Huh?
We have been accommodated as a tutor.
No, what about the other side? Elementary education? Yes, elementary education. I saw Satyajit here. Who appears for NJ Khatuniar? You appear? No. No, you are for secondary. Elementary is required.
Elementary also.
Oh, you elementary also. Okay.
But we are awaiting instruction in this one.
Upgradation, have prayed for upgradation of their supernumerary post of assistant teacher, post of teacher along with. Okay, let them file the affidavit. They have not filed.
We have
Heard
waiting.
Mr. S.B. Loskar, learned counsel for the petitioner, and Mr. B. Kaushik, learned standing counsel for elementary education. Mr. Kaushik submits that some time be given to him to file the affidavit in opposition. As such, which is allowed. As such, list this matter on 24th of July.
Well,
Non-payment of area salary method.
Yes. Huh?
This matter may come matter in the month of August, matter, because matter due to the lack of budget, matter we could not proceed. Matter.
Otherwise, dispose of the matter within 2 weeks.
Matter that can also be done, matter.
What is this matter? That can also be done, you said, right? Ah. What is this?
Non-payment of arrears salary.
Non-payment of arrear salary.
77.
Small amount, but
Small amount to the tune of what?
77,000.
70?
7,000.
77,000. Yeah, you can give him yourself. Yes, just take me to the relevant annexures.
Lordship, Lordship, come to synopsis here.
Hmm.
So clear.
Page 10, madam. How did you do that?
Mhm.
Page 10, madam.
Page 10, yes.
Annexure 2.
Lordship, it is a retired Lordship assistant is.
So this is specific budget allotment
Minor,
of fund in connection with drawal of arrear salary. And then non-drawal. So you want funds for this 77,000?
Minor.
No. Acha, take me to the annexures. What? You said synopsis.
Lordship, synopsis is shortly and
Acha. Okay.
last annexure Lordship, this is a forwarding letter from page 18
Huh. This is by
by
district elementary to director secondary.
Lordship, proposal sent.
Proposal sent.
That is the letter.
Okay, heard Mr. Yes, Lohit Gogoi,
Lordship.
for learned counsel for the petitioner, and Miss S. Chutia, learned standing counsel for elementary education department, and Miss Borua for finance.
Finance department.
For finance department. What Borua you said?
RM Borwell.
R.M. Borua, huh? I forget these initials. R.M. Borua. By this application, filed under Article 226 of the Constitution of India, the petitioner has prayed for a writ of mandamus, directing the respondent authorities to pay the arrear salary of rupees 77,544 to the petitioner. Full stop. The case of the petitioner is that he was appointed as the assistant teacher in Robidaspara. Rabidaspara. Horizon MV School, Silchar, Kachar. Horizon MV School, Silchar, Kachar. On 13/1/1984. And that after his tenure as the said teacher, he retired from his service on 31/12/2021. The petitioner further states that after his retirement, he had received all the pensionary benefits, including the monthly pension, but he did not receive one arrear salary of rupees 77,544. Full stop. He submits that the said amount was due to him on account of his third financial upgradation under Modified Assured Progression Scheme, MACPs. And the period for which he is entitled to get the arrear salary was from 1/1/2017 to 31/10/2022
20, 21, 10.
or 2020. It is the further case, it is the further case of the petitioner that the district elementary education officer, Kachar, by a memorandum dated 1/10/2020, had directed the block elementary education officer to release the financial upgradation to release the amount, to release the salaries, To release financial upgradation, that is what the language is. To release the financial upgradation. Which the teachers are entitled under the Modified Assured Career Progression Scheme. And in pursuant to the same, one list was prepared and the petitioner was at serial number 16. He further states that in pursuance thereof, the Deputy Inspector of Schools forwarded the proposal for payment of area salary to the petitioner by letter dated 2/8/2025, and that thereafter the District Elementary Education Officer, Kachar Silchar, forwarded the said proposal of area salary to be paid to the petitioner to the Office of Director of Elementary Education on 5/8/2025. But it is the case of the petitioner that till date he was not paid with the said amount. The learned counsel for the petitioner submits that the petitioner is entitled for the said amount under the MACPs, Modified Career and MACPs, and proposals were also sent for the payment of the same, but till date he has not been paid. The learned counsel for the Elementary Education Department, Ms. S. Chutia, has placed an instruction by which it is intimated that the area salary proposal in respect of the petitioner could not be submitted to the government for sanction due to lack of budget provision in the respective head of account during the financial year 2025 to 26. The learned counsel for the finance department submits. What are your submission? That
Lordship, regarding the area salary, the proposal has to come from the administrative department. Once the proposal comes, we'll clear it, Your Lordship, we'll disperse.
proposal had gone, but not to you.
Not to us, sir.
Submits that proposal had not been sent. A proposal for payment of area salary. For payment of area salary has not been sent to the finance department. And once that proposal is sent by the authorities concerned, there is no objection on the part of the finance department to clear the dues. On consideration of the submissions made by the learned counsels, it is therefore directed that the Director of Secondary Education, Director of Elementary Education would send the proposal for payment of the area salary due to the petitioner to the finance department, who would in turn disburse the same.
We'll give the financial sanction and then the
Administrative department will
disperse.
Disburse the same to the administrative department of the school of the elementary education. Administrative Department of Elementary Education. Full stop. Since it is noticed that the petitioner is entitled for the said amount, and a list was also prepared wherein the name of the petitioner finds place for payment of the same, and only due to the lack of budget, the same could not be proceeded on. কি বুলি কলো প্ৰথমটো? It is therefore directed that the necessary exercise be conducted within a period of 2 months from the date of the receipt of this order by the authorities, that is the Office of the Elementary Education as well as the Finance Department. Full stop. Within 2 months from the date of this order by so and so. No, it took question by so and so. Petition is disposed of. Within 2 months you do it. Petition is disposed of.
Obviously.
19 কি হয় এইটো? Yes, 19 এইটো কি? এইটো নহয়।
Lordship, I was supposed to bring.
দুখন just a second. মোক দুখন লিষ্ট দিছা নি? মোক দুখন দিছা। এইখন নালাগে এইখন। এইটো। Yes. Yes, what happened?
Lordship, I was supposed to place the instruction regarding the process, what happened, because hearing was called for, petition was, and the process is not complete. Now department has sent for some verification of the certificates of the.
Wait, let me read the last order. What is that? Applied for the post of assistant professor. Advertisement. Thereafter came to know it was selected but not applied because of the reason the complaint is filed. It is such a director and submitted a representative and the director outcome of the said hearing. What
Yes.
happened?
Now, hearing has been not completed. It is
Hearing not complete.
Not completed.
But then last time you said
No, hearing in respect of the petitioner was completed, but the subsequent verification is still pending. We have communicated to the university also, Gauhati University, that outcome is required.
oh.
So some time will be required.
So what kind of a complaint is against him?
Against her.
Against her?
Yes, Lordship. The one Dharitri Soikia that responded, she has made a complaint that her qualification that she should ought not to have been given some marks. And regarding the Dharitri Soikia, also one complaint is there. Her PhD degree ought
Oh
not
my
to.
God.
So that
Both wants to stop the
Yes,
other one to
that-
get a
that's
point.
the-
My
that's
God.
the issue, Lordship.
Okay, you bring the outcome of the verification
Some
of
time
the
will be
records.
required because Lordship, the verification of both the candidates are under cloud, Lordship, the doubt.
Acha.
That's right.
Okay, may I heard Mr. D. Mohanto, learned counsel for the petitioner, and Mr. A.R. Tohbildar, learned counsel for Higher Education Department.
Lordship.
Mr. Tohbildar submits that the
Process of
hearing with regard to the hearing done in connection with appointment of the petitioner to the post of assistant professor in botany department was conducted, but the verification of certain documents are still left.
Yes.
As such, he prays for some time so that he can apprise this court
Lordship.
about the outcome of the said verification.
Lordship.
Prayer is allowed. List this matter on 24th of July.
Lordship, in the first week of August, Lordship. Can it in
First week of August?
Yes, Lordship.
List this matter on 4th of August.
Maybe
Oh, it outcome will not be there.
See, I'll be in the middle. 27th of July.
I'm like,
Yes. Then 12 for orders. 7 as orders, okay, 12. Oh, no. You give me back that list. On Thursday list. Chicken logos diokson. Yes, just a second. Something wrong with my cause list. Yes. Item 12. What happened?
May it please your lordship. Your lordship, in this contempt case, the other side has filed an affidavit in opposition. We want to file an affidavit in reply.
What is there in affidavit opposition reply in contempt cases? They have to follow the order of this court. What happened?
Only thing is that we have preferred a writ appeal, my lord.
Oh, you have preferred a writ appeal. What
That-
happened to that?
Yet to be listed.
Yet to be listed.
Yes, my lord.
They delay.
There is a delay because the order in the writ petition, they have submitted after 1 year, my lord.
Huh.
So there is a delay of more than 600 days.
No, you have delay in preferring writ appeal.
Yes, my lord, because we have got to know about the order after 1 year, my lord.
Oh,
That is why.
so delay is condoned.
No, my lord, it is yet to be listed, delay application.
So
my
how
lord,
long?
take it after vacation, my lord. In the meantime, I will ensure that the writ appeal will be
They
listed.
have filed an appeal against that order. But of course, with a
Want to file
big delay.
an affidavit in reply, ma'am. for
Okay,
that.
you also in the meantime file your affidavit in reply. Okay. Heard Miss
B. Chaudhary.
B. Chaudhary, learned counsel for the petitioner, and Mr. N.J. Khatunier, learned standing counsel for elementary
Yes, my lord.
elementary education. Mr. Khatunier submits that the state has preferred an appeal against the order, the non-compliance of which is alleged in the present contempt petition. He as such submits that the instant matter may be taken up on a later date. Miss B. Chaudhary also makes a prayer that she requires some time to file the affidavit in reply to the affidavit in opposition filed by the state respondents. Prayers are allowed. List this matter on in the mid-August.
Yes, yes, ma'am.
List this matter on 12th of August, 2026. Yes, Mahanta.
Last order, Lordship.
Some BTC
Lordship.
problem?
Appointment.
As per my
BTC has not done something for you?
as per my telephonic instruction, Lordship, the compliance is in process today itself, Your Lordship. So,
Acha.
Lordship can be posted next week.
Next week?
Any date, Lordship.
Why do we keep it pending?
Lordship, absolutely. Perhaps on the
Okay,
Thursday.
heard D. Mohanta, learned counsel for the petitioner, and Mr.
NR Sharma, Lordship.
N.R. Sharma, learned standing
For respondent number 1, Your Lordship.
for respondent number 1. Mr. Sharma submits that the compliance of the order which is challenged for its non-compliance has been in process, and that he would submit that compliance order by next week. Accordingly, list this matter on 24th of June.
24th July.
In this case, I am paying for some time to take up to date instruction, my lord.
Okay, yes.
Order was passed on 2024, my lord.
Hmm.
Almost 2 years, my lord.
When a contempt was
And,
preferred in the year
I would call
2025
directed
also.
to
Immediately after
within
vacation,
3
ma'am.
months, my lord.
Comply. Whatever is required, you
Fine.
do it. Okay.
Ma'am.
What is your order?
Order- Lordship, One,
And just tell by yourself, yes.
one annual increment, my lord,
Annual increment
Yes.
was stopped.
not stopped, my lord. I was eligible. I
Acha. It was
completed
not
the-
given to you.
Yes,
Okay, she wants immediately after the vacation, we will take up. Heard Mr.
HL Ashko.
H.L. Oscar, learned counsel for the petitioner, and Miss S. Chutia, learned standing counsel for elementary education. Miss Chutia prays for some accommodation to the effect that the compliance is in process and that she would like to file an affidavit bringing into record or not an affidavit.
Not if you only instruction, my lord.
And that she would bring the instructions on the next date fixed. Accordingly, list this matter on 17th of July.
Ma'am. Obliged.
Yes. What is this contempt about? Due to paucity of time, what happened?
May it please your lordship. Lordship, violation of order dated 1/8/2020.
Elementary.
Secondary Education Department. Lordship.
Oh, secondary education.
Complete.
Acha, services complete.
Yes, lordship.
Chishti was there. And prayer not being open, let the matter be listed. Obtain instructions in the matter.
15.
Yes, Mr. Khatonia,
Yes, my lord, I will obtain, my lord.
please obtain it.
Yes,
And number of months have gone.
yes.
Okay, we heard Miss
F. Begum.
F. Begum, learned counsel for the petitioner, and N.J.
No.
Khatonia,
No.
learned standing counsel for elementary education. Mr. Khatonia submits that he be given some time to bring the latest, to bring the instructions. Full stop. It is also noticed that instructions were sought to be placed since March 2026. No. Since April 2026. And as such, a last opportunity is given to them to place the instructions without fail on the next date. List this matter on 20th of July, 20?
Yes, madam.
20th of July, 2026. But you bring it, huh? Last
Yes,
last
yes,
opportunity.
Lordship, after 20.
Acha. Let's this matter on 24th of July. Okay, 24th.
24.
Yes, Mr. Fuka.
Wait, please, Lordship.
Don't say that instructions are awaited.
No, my
Tell
lord,
me.
what has happened is in this matter, on the last occasion, the matter came up on 8/6/2026. Lordship, the matter was fixed today. On that day, my lord, the high power committee sat, my lord, as per compliance. But unfortunately, the report is not being, they have not signed the report. They'll sign it, my lord, because one of the members was ill. So, my lord, we'll fix it on Wednesday, this Wednesday. They will produce the compliance order.
Okay.
So that's what the telephonically they told me. Because already the high powered committee sat on the last date on 8/6, and my lord, just the sign is required for the report to be posted.
Okay. Mr. A. Fukon, learned counsel for the respondent, submits that that pursuant to the order dated 8/6/2026, the high power committee had discussed the matter and had taken a decision, but the said decision could not be signed by one of its members because of his illness, and as such he prays that next week he would place the decision of the said high power committee without fail. Accordingly, list this matter on 24th of June, Wednesday.
Deeply admit.
So, contempt, yes.
Lordship, in this contempt petition, the notice has been issued, service is completed, so the matter pertains to the provincialization of services. The names were left out because of the non-inclusion of their names in the UDICE code.
In the?
In the UDICE code. Your
The
Lordship.
UDICE code, okay.
Yes, Your Lordship.
So, yes, you, Sharma,
Yes.
shall place on record, you were not there.
Yes, madam.
Record the status with regard to implementation of the directions, yes.
His name has not been shown in the cause list, madam. That is why maybe
But then you are there, what happened? 20?
20, madam.
Oh,
Name
the
has not
name
been
is enough. The name of the respondent is enough. Srimati
That is why
Mamata Hojai.
that is why I'm here, madam.
Yes. So you can again place some instructions.
Yes, yes, madam.
So,
On reopening on 24/7, madam, on
Okay.
same date.
Mr. N.J. Khatuniya, learned standing counsel for elementary education.
Secondary education.
Or secondary education submits. মই আগতে elementary question কি তাৰ হয়?
In fact,
Both.
both, madam.
Oh, acha. For secondary education, what did duita? Secondary education has submitted that the names of the councils are not reflected in the cause list, and as such, he could not bring the necessary instructions required in this case, and has prayed for some time. Prayer is allowed. List this matter on
24/7, madam.
24/7/2026.
Okay.
Last name.
Possibly pleased to say your lordship's last order, lordship, on 2-3 occasions and they took time, they received section that it received.
That he has parawise comments,
Yes.
but he
Madam,
did
he is
pay.
preparing the
The issue
affidavit.
is very simple, lordship. Insurance
So,
order.
without the affidavit, I'll hear you.
Fine.
Pay.
Yes.
Okay.
But the-
Can it be disposed?
But the issue is settled already, lordship.
Acha, then okay.
Page 30, we improve order.
You don't have to worry. Nothing will be adverse against you. Yes, then? Yes.
Page 34.
Page 34.
Lordship, this was the impugned order by read. May I read, lordship?
Yes.
As per proposal received from B.O. Lahorigat by letter number so-and-so, Shekhar Jyoti Rahman, senior most.
He is the petitioner.
Yes. No, he is the respondent number. I have taken trustee survey also, but he did not appear, lordship. A respondent number 5. Now, he is allowed to hold the charge. Although I am this
Wait, allowed to hold the charge of in-charge headmaster.
in-charge headmaster
Okay.
of Lahorigat LP school. Now, lordship, come to the appointment order. I was appointed in the year 2012, 19/5/2012,
Where?
page 16.
1/6.
1/6. Page 16, order dated 19/6/2012.
Wait.
And-
16. Yes.
And so far the respondent number 5,
This is what date? 19/5/2012.
19/5/2012, the
And-
petitioner was appointed
Petitioner was appointed as a?
assistant teacher
Huh.
in Lahorigat LP school.
Hmm.
Now the respondent number 5,
Hmm.
his appointment order is 28th of June 2013, annexure 4, page 21.
13. After you.
Yes,
21.
21.
Okay.
Now, on 28th of June 2013, the name of the petitioner 175, his appointment was at Chandralekha Konaglata LP School. So initially his appointment was at Konaglata LP School. Now, Lordship, in 2016, that Lordship, his joining letter, Annexa 5, page 24. 11/1/2016.
Yes.
This is the joining letter of the respondent of 5.
In Konaklata
No,
LP.
the
No.
Lahorigat LP School.
I have been transferred from
With
Kumar
reference to
LP
the
school?
subject, I have the honor to, I have been transferred from Madhuram Kumar LP School to Lahorigat LP School by government letter number 23/12/2015. I therefore hereby join as a regular assistant teacher of LP School on 11/1/2016. So this was on 11/1/2016.
And his seniority will be counted from 2016.
In my school, Lordship, we from 11/1/2016. So on that count, Lordship, I am the senior most teacher, Lordship.
Otherwise also you are senior.
Yes. So I may be allowed to hold the charge, Lordship. And this is a temporary order. In fact, Lordship, initially, Lordship, the school authority has given, but approval was not given. But ultimately, Lordship.
Where is that? Approval not given, school authority had
Lordship,
forwarded?
Annex 10, Lordship. This is the report of the block limited education officer.
You
Proposal-
Firdaus Hussain, head teacher.
For IC headmaster, page 33. With
Wait,
reference.
what is your name?
My name.
Hasnara.
Yes, Hasnara Begum.
Acha, this is in connection with Firdaus Hussain, has been transferred to other district and
Now,
he has handed
this
over
fell vacant because Firdaus was the
in charge.
initial headmaster. Firdaus Hussain was the headmaster of the Lahorigat LP school. He was transferred. His transfer order is at page 28.
It's okay, he was
So
transferred.
after his transfer, the post is fell vacant. Thereafter, I applied for the
He had handed over the charge
To
to
me.
Hasnara.
yes.
She has been rendering her services in charge.
But at the time of Lordship approval to this proposal, the authority has Lordship rejected my claim and the respondent number 5 was allowed to hold the charge. And this by this honorable court on various category of judgment Lordship, it is stated that if somebody is transferred from one.
Maybe
school to
provided the order of so and so. Okay, this is by BEO.
BEO.
Then what happened?
Then impugn order Annex 11.
Oh, that Shekhar Juti was
Yeah.
given. Senior most regular assistant, but this is a wrong finding.
Yes.
Senior most regular assistant teacher
Lordship.
of Lahorighat.
Lordship.
His seniority will be counted from 2016.
16, 11.
And she has been in the school right from the date of appointment
Yes.
in
12.
2012.
12.
Right.
So I am relying on the decision of 2002-1 JLT, where it's that the school seniority, let's say, when a person is on being transferred from one school to another school on his own request, is entitled to carry his seniority or not. Hell, whenever a person is transferred on his own request from one school to another, he or she loses his seniority of that school.
That is the subtle position, I think.
So this impure order will be set aside and the authority will be directed to give the
To consider.
to the senior school.
Consider.
Lodge.
Without the affidavit and all direct, I cannot give. To consider his
My
appointment.
lord, may period page 16, my lord, Annex R 1, my lord. Petitioner is a contractual teacher, my lord.
As per the advertisement, the following candidate is selected by
No, it's a true regular selected.
assistant teacher. in
Maybe, my lord,
Chittorgarh
but on
Primary
contractual
School.
basis, he
Purely on contractual
Contract-
basis and terminable. And what happened?
But
He is regularized.
no, Lordship,
No.
the page 19, we are giving the benefit of school, page 19, their own notification, 2020.
19.
19,
Then cabinet
Lordship,
decision.
clause 4, Lordship, entitlement of salary as per revision of pay rules and benefit of service, same benefits are
My
getting.
lord, this is my lord regarding my entitlement of salary, my lord. Now,
Yes.
petitioner is praying for my lord,
No,
in
we are-
fact, headmaster, my lord.
We are getting the same benefit, same salary. My appointment of 2012, but while my appointment was done also on a special drive by the Sarva Shiksha Vision, this was sitting that contractual appointment. But that is why the authority has issued this notification of 2020, saying that we are also getting the same benefit.
My lord, that issue is pending,
Clause
my lord.
four.
Whether they will get the benefit or not, my lord, that issue is pending, my lord.
There is no such issue. We have, there on many occasions, they took time, they have not filed affidavit. Let's see, Annexure 3, page 19, from the
One
commissioner.
second.
Entitlement of salary as per revision of parallel 2007 to ROP rules and benefit of CPF, etc. will be continue as per existing system. So we are getting the same benefit. So if we go by the date of joining or seniority, then I am the senior.
Okay, on the basis of that forwarding letter by the BEEO,
Yes.
that consideration order can be given.
Annexure 10, page
Annexure 10. See Annexure 10.
And initially, the earlier headmaster, he allowed me to hold the charge.
This is what is stated. She has been rendering without any departmental order as per resolution number 8
Approval is not given.
of SMC's executive meeting held on Iman to hand over the charge of in charge headmaster to Nigam as a senior.
Ultimately,
assistant
DI has
teacher
given
with
approval by order
school.
dated 14/10/2025 in respect of rational 5.
State headmaster, head teacher, in charge head teacher.
You should have pending as a head of the government.
This is also regular. It's just to, this is on the issue. What's the point and the posting question is for insertion.
Well,
They are
if that
saying
case,
that-
madam may take it up immediately after vacation, madam. In the meantime, we will file our affidavit, madam. Because the
Yeah.
issue is pending, madam.
And
Regarding they will
See,
get the
we
benefit or
don't
not,
know
madam.
whether the head teacher post is sanctioned for the LP school or not. That is completely different.
No head teacher post is there, madam.
But this is for insertive lordship.
Okay, in view of that, I'll go
Annexure
to the
10.
other areas, but in view of his BEO's letter, his case may be considered. This is what. And if otherwise not found ineligible,
Lord.
Madam,
right?
madam.
He was mutually transferred.
Yeah. He himself admitted.
Somebody else went to his place, right?
Yes. That block elementary lordship letter or 21/1/2016. That is stated lordship, page 26. With reference to such that the service of has been booked in original, including last pay certificate, Safar duty, so and so, under is the establishment of block elementary education officer regarding mutual transfer. So at his own request, lordship, he has been transferred in 2016.
And this is not in charge headmaster, the head teacher. Head teacher and headmaster are different, right?
No, but in a LP school, actually, it is known as a head teacher.
Oh.
There is no post of nomenclature as a headmaster. So
Okay.
for the ME school, it is
Huh.
headmaster, and high school is headmaster. And in higher secondary school, it is the principal.
What is this additional affidavit you had filed for?
That was for lordship justice serving.
Oh.
And he also, after receiving the notice, also did not turn lordship.
Okay, heard Mr.
Yes, sir.
A. Deka, learned counsel for the petitioner, and Miss S. Chutia. Don't worry, don't worry. The order will not be effective. It will be effective, but not affect you. Okay, heard Mr. So-and-so and S. Chutia, learned standing counsel for elementary education department. By this application,
I am looking for response number 6, SSA.
Acha, and Mr. S. Bora for respondent number 6, that is SSA. The office note dated, the office notes reflects that service upon respondent number 2 is complete and the petitioner.
It is five lordship.
And the petitioner has also filed an affidavit showing that that the service is complete by way of a dusty full stop. But there is no representation on behalf of respondent number 2. And as such, in his absence, the petition is,
Instead of 2, it is 5.
oh, respondent number 5. Wait. Respondent number 5. And as such, the instant case is taken up for disposal. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for a writ in the nature of certiorari for quashing of the order dated 14/10/2025 issued by the Deputy Inspector of Schools, Morigaon, by which, that is that order, 14/10 order, by which respondent number 5, namely Shekhar Jyoti Rahman, was allowed to allowed to hold the post of in charge head teacher of Lahori Ghat LP School. Full stop. The case of the petitioner is that is the only prayer, right?
Yes.
The case of the petitioner is that she was appointed as an assistant teacher by SSA, Samagra Shiksha Abhijan. Samagra Shiksha Abhijan. Wide advertisement dated 14/2/2012 and was posted at Lahori Ghat Lower Primary School, hereinafter referred to as the school. Morigaon. It is stated that the petitioner was appointed as in contractual basis. The petitioner states that she has been continuing in the said post till the date of her joining, that is in the year 2012. She further states that the respondent number 5 had joined, was appointed, respondent number 5 was appointed, where is that?
Page 21.
Was appointed as assistant teacher at lower primary school, at lower primary school. Which school?
Name of the school is Konaklata LP School.
In Konaklata LP School. On a temporary basis. By order dated 28 June 2013.
Thereafter transferred.
Thereafter, the said respondent number 5 was transferred. This is a different school.
Page 24.
From her?
Page 24. Initially Konaklata, from Konaklata to then Madhuram, and finally.
Where is that? Where is that? Where can I
Page
find it?
24. His joining letter.
No, that is okay. From Konaklata to Madhuram.
That order, I have not anything. But from this, it reflected.
It is heavy. Thereafter, no. The petitioner further states that that respondent number 5 was transferred from the school he was appointed to other school, and by order dated 11/1/2016, he was transferred from Madhuram Kuar LP School to Lahori Ghat LP School, to the school. Jodi hearing after kursa.
On a regular assistant teacher, my lord. It is written here, dear my lord.
As a
As a
regular
regular assistant teacher.
Lahori Ghat to the school. While ordered, no kulu, no? Was to the school. It is reflected in the said transfer order that he is directed to join. Oh no, he had joined the said school as a regular assistant teacher in. This is by Shekhar Jyoti only.
My lord, because
not
my
required.
petitioner is my lord contextual teacher. Contextual teacher are not eligible to the post of my lord head teacher, my lord. This
But
is
then there is a reference. So on that basis, if something can be done.
It is not only in notification, my lord, there is only in regard to
Lordship,
the
it is
pay
a
scale, my
cabinet
lord.
decision, Lordship. Lordship, kindly have Annex 3, page 19. In pursuance of cabinet decision.
Wait, I'll go to. So and so, huh?
My lord, that issue is pending before this honorable court, my lord, in another set of litigation, my lord.
Okay. It is the further case of the petitioner that that by a notification dated 1st of July 2020, issued by the Commissioner and Secretary to the Government of Assam Elementary Education Department,
In pursuance of cabinet decision.
there is a notification issued by so and so, by which it was notified that in pursuant to the cabinet decision dated 26/5/2020, additional service benefits to 29,701 numbers of teachers working in both lower primary and upper primary schools as contractual teachers. Number of assistant teacher did this working in contractual basis.
Clause 4, Lordship. Entitlement of salary.
Were given. Were given. No, but contractual teachers, no. Working in both lower primary and upper primary schools and who were engaged during the period from the year 2011 to 17 and who had joined on or before 1/1/2018 were given. Were given, full stop. And in the said notification, it was stipulated that the service of such teachers would continue till they attain 60 years of age, subject to their satisfactory performance report, along with medical reimbursement benefits, as well as leave benefits and salary benefits, full stop.
As per revision of pay, Lordship.
Salary benefits as per revision of pay rules.
Yes.
She thereafter submits that the block elementary education officer. What are these? These are Shekhar Shumans. Shekhar Jyotis.
Shekhar Jyoti.
A service book in original. Mutual transfer, which is okay.
Then
What is
page-
this chart? Annexure 7, page 28.
Annex 7.
This is also Firdaus
Annex
Hussain.
7, page 28 is the order by which the earlier headmaster of the school is transferred. So when he transferred, that post is fell vacant, then immediately being the senior most teacher, I applied. It is Annexure 8.
Annexure 8.
Sorry,
No.
Annexure 9, page 31. But
Annexure
ultimately,
9.
Annexure 9, page 31.
Acha. The petitioner further states that the post of in charge head teacher fell vacant on transfer of Sri Firdaus Hussain to other school. And the vacancy having arisen, she applied for the said post before the Block Elementary Education Officer, Lahori Ghat, by application dated 22/8/2025. She applied for the said post on the basis that she was the senior-most teacher of the said school, having appointed in the year 2012. In pursuance thereof, the Block Elementary Education Officer, by letter dated 16/9/2025, to the Deputy Inspector of Schools, Morigaon, had recommended, had intimated that the earlier incumbent, having transferred to other district, the charge of head teacher of the school was handed over to the petitioner, she being the senior-most assistant teacher. It was further intimated by the said letter that petitioner has been rendering her service as in-charge head teacher with the with effect from
22/8/2025.
that the day when he was transferred, 22/8/2025 till 16/9/2025,
Yes, thank you, Madam.
without any blemish. It was further intimated that as per resolution number 8 of School Management Committee's executive meeting held on 21/8/2025, the charge may be the charge be handed over to the petitioner. By the said letter, it was further informed that respondent number 5 has also made his prayer for appointment to the said post of in-charge head teacher of the school. And finally, the Block Elementary Education Officer by the said letter had recommended that as per resolution number 8, petitioner be provided be allowed to work as in-charge head teacher for the smooth functioning of the school. However, the Deputy Inspector of Schools, by order dated 14/10/2025, had passed an order allowing respondent number 5.
As per the proposal received from the BEO, my lord. This is also from BEO.
Respondent number 5.
Yeah, can accept it.
কি করলো? No, he finally, no, yes. However, episode. No, by order dated so-and-so, had allowed respondent number 5 to hold the post of in-charge head teacher of the said school. And in the said order, it is stipulated that respondent number 5 is the senior-most regular assistant teacher of the school.
My content is that is a wrong assertion, Lordship.
Whatever the department will say. It is this order that the petitioner has challenged in the instant writ petition. The learned counsel for the petitioner submits that the petitioner was the senior-most teacher of the said school, and although she was arrayed as a contractual teacher, but all service benefits were given to her, and the block elementary education officer had the school managing committee in its meeting held on 21/8/2025 had taken a resolution to hand over the charge of head teacher to the petitioner. And in pursuant to the same, the block elementary education officer had also written to the deputy inspector of schools for such appointment. He as such submits that the petitioner should have been appointed as in charge head teacher of the school. On the other hand, Ms. S. Chutia, learned standing counsel for...
Important here, he transferred.
Oh, yes. He further submits that respondent number 5 is not only junior to the petitioner by seeing the date of appointment, but also due to the fact that respondent number 5 was transferred on his own request to the school on
23 by order on 11/1.
On 11/1.
By order dated 23/12/2015.
Where was that?
That pay Annexa 5, page 24. Actually, this is the joining letter of the respondent number 5 in Lahorighat LP School. The date of transfer is 23rd of December 2015.
Transfer ki kolo last on 23/12/2015. As such, he submits that, that respondent number 5 is much junior to the petitioner, and he cannot be appointed as head teacher in place of the petitioner. On the other hand, Ms. S. Chutia, learned standing counsel for elementary education, submits that petitioner was appointed on contractual basis in the year 2012, and she has been continuing as a contractual teacher till date. She submits that the cabinet decision was only to give service benefits to the contractual teachers under Assam Sarva Shiksha Abhijan mission. And as such, he submits that a contractual teacher cannot be given in charge head teacher of the school. And respondent number 5, being the regular teacher, was seen eligible and was accordingly allowed to hold the charge of the said post. Prepara. On consideration of the submissions made by the parties and on perusal of the records of the instant case, this court finds as follows. The petitioner, what is the rule of in-charge head teacher?
Sorry, there is no direct rule.
No,
normally the senior most teacher is allowed to hold the charge.
That is the norms.
That is the norm, but there is in rule 1977.
But
specific.
This is elementary education.
Elementary. Assam Elementary Education Service Rules 1977.
Ouch. So that is the post of headmaster is provided in which rule?
There is a notification. In the rule, there is no provision provided how to the selection process to be made. So in 1986, the notification has been issued from the authority. They followed that particular notification.
On the basis of seniority.
Yes.
Seniority come efficiency.
In the book.
Seniority come efficiency.
Yes, seniority
come efficiency.
Where? What is the rule you said? Elementary education?
No, you lordship will not get in the rule lordship. The rule
Assam
Elementary Education Provincialization Service Rules 1977.
Okay,
But
293.
the rule does not provide any procedure for promotion for selection of headmaster in LP school.
Okay.
It is only by way of a notification. Notification will not be in the manual. it says Lordship seniority and efficiency.
Seniority cum efficiency.
The notification mentioned in the rules.
No, separately it is mentioned.
आपण minute मध्ये माहिती देऊ.
Minute.
So,
You were in education department
Yes,
for law,
that is-
so you will be knowing. Eto.
First
কি করবো?
notification
হ্যাঁ।
1986.
She was
Thereafter
appointed.
it is 2010.
Appointed, no? Follows. The petitioner was appointed as an assistant teacher in the school
Yes.
on
Yes.
19/5/2012, and she was appointed pursuant to an advertisement dated 14/2/2012.
So, Page 318.
14/2/2012.
ME, MD and D school.
And her appointment was pursuant to the selection done by Assam Sarva Shiksha Abhijan Mission. It is also seen that before appointment of the petitioner as assistant teacher of the school, a resolution was also by the school managing committee, right?
School managing committee.
Wait. She was selected by the SSA.
No, and this was when advertisement was issued.
Hmm.
That's page 16. Advertisement is of 14 February 2012.
Following
By
candidates
following
selected.
the selection procedure under 1977, the petitioner was appointed, but this is a special recruitment drive. That is why it is written as a contractual appointment.
Okay,
Ultimately, benefit is
it
given by the notification of 2020.
Under
Acha.
statement.
Same benefit, Lords.
Yes, to কি করল এটা না লাগে হেইটো না লাগে যে ম্যানেজিং কমিটি না লাগে সিলেকশন বাই অসম selected by Assam Sarva Shiksha Abhijan Mission, which was for mission, full stop. The SSA mission appointed the petitioner in their endeavor, during their endeavor for engagement of assistant teachers in lower primary schools in Morigaon district of Assam. The petitioner is seen working in the said school since the day of her appointment. Full stop. On 1st of July 2020, it is seen that the cabinet, by its decision taken on 26/5/2020, provided additional service benefits to the contractual teachers, including payment of revision of pay rules, including benefits under the revision of pay rules
I think the same benefit.
and benefits of CPF, etc.,
Those teachers are also getting same
which
benefit.
were given to the regular teachers.
Right.
It is also seen that the head teacher of the said school who was transferred had given the charge of the head teacher to the petitioner, and the school management committee by its meeting dated 21/8/2025 had passed a resolution in the form of resolution number 8 to hand over the charge of head teacher to the petitioner, and she was adjudged the senior-most assistant teacher of the said school. Pursuant to such resolution, the block elementary education officer had also, by letter dated 16/9/2025, had intimated that petitioner was given the in charge of head teacher given the responsibility of in charge, of head teacher, not only by the transferred head teacher of the school, but also by the school managing committee. Where is the this notification?
This notification is specifically for, although this school is falls under elementary schools, now till today, the post of head teacher is not sanctioned in LP schools. But the nomenclature is their head teacher. So that is why on the basis of seniority, the senior most teacher is given the HR. They don't give any other benefit, only 300 rupees they are getting.
As
That is
further,
in that notification, the LP school name is not there. It is MEMV school.
further by relevant notification, as well as the norms provided by the respondent authorities, the head teacher of the LP schools are given on the basis of, are appointed on the basis of seniority of the teachers of the respective school. It is seen that petitioner is the senior most teacher of the said school. Although she was working on a contractual basis, but all other benefits were given to her. And respondent number 5 had joined the said school much after the petitioners, much after the petitioner. As such, this court deems it fit to direct the secondary director of secondary education, director of elementary education,
They interfere with this order 1410.
director of elementary education to consider the case of the petitioner for being appointed as the head teacher of Lahorighat LP school
On in charge basis.
appointment as in charge head teacher, as in charge head teacher of Lahorighat LP school. In view of the same, the order dated 14/10/2025 stands quashed, and the Director of Elementary Education is ordered to pass a fresh order after considering the case of the petitioner.
Time frame.
Till then, my lord, the BO is directed to take the charge, my lord. Otherwise, midday meal and that will be.
And during within a period of 2 months from the date of receipt of this order, and in the full stop. In the meantime,
DU Lahorighat, my lord.
no, inspector of schools can, deputy inspector of schools can also hold a charge, but
Because he the order may be passed by the higher authority director. That is, but the till then also as one of for he will look up 30 midday meal. As one of for block elementary education officer, because under his block this school is Lahorighat. That's one of for the right person.
Right
to-
person, my lord, respond.
Yeah.
Decision will take by the higher authority director, my lord, but school has to.
no,
be
in the meantime, who will run the school?
Respond number 4, my lord.
Block elementary. In the further, in the meantime, till the fresh order is issued by the Director of Elementary Education Assam, the Block Elementary Education Assam,
Officer, my lord,
or
Lahorighat.
Block Elementary Education Officer
Lahorighat.
may be given the responsibility to continue, to hold the in charge head teacher post. No. To take the responsibility.
Responsibility, my lord.
To take the responsibility of the in charge head teacher post.
Not post, my lord.
Not post. To take the responsibility of the school.
Functioning of the
To
school, my lord.
take the responsibility of, take the responsibility for smooth functioning of the school.
My lord.
Petition is disposed of.
That block elementary education of Lahori, that may be indicated. That block
Elementary education
Lahori.
officer Lahori Ghat bili dia.
Under that block,
Ah.
Lahori, this school is a.
Mm.
Deep level.